Just wait. When do we want? What is the urgency? Next week. Next week. 29. 29 is what? Monday? Friday? Okay. Yes. Hmm. You file it, it will be list along with that only. Okay. $27. What is the matter? Hmm. From foreign firms. Supreme Court has already passed on. You have filed the affidavit. Yes, call it. We'll see. Item 3. Yes. Hmm. Okay. Which for the petitioner? No objection. What? Okay. On the prayer of Mr. P. Bhartwaj, Learned Counsel, appearing on behalf of N. Barua. Fresh foreign is granted a week's time to 2 weeks time to, or it will be 2 weeks only. Then after a week, for Fresh foreign is granted a week's time to file affidavit. Okay, no. Then in that case, Fresh that submits that Mr. N. Barua is indisposed today. Therefore, press for listing of the matter after a week. List of as agreed to be and conference for the parties, let this matter be listed on 4th 09/2025. Yes. Yes. No, why? If it is filed, it will be listed only. It's not automatically listed. If the defect it has been cleared, it will be listed. It's all right. Okay, continue. Why? What is the urgency? Okay, we'll see. Yes, I've seen it. Last occasion also, because of that only we have adjourned. Day after tomorrow, Thursday, huh? On the prayer of, you have taken the consent? Yes. Kindly inform them. They may again, on the prayer of 9/2/2022, huh? Mr. P. Nayak, Learned Counsel, additional advocate submits that in these matters, Learned Advocate General is appearing, however, due to personal difficulty, could not he is not available, therefore. Okay, in that case, submits that in this matter, learned advocate general appearing. However, today the learned advocate general has some difficulty in arguing the matter. Therefore, press for listing of the matter on Thursday, i.e. 2028. Okay. Interim order passed earlier shall continue. Huh. 23. Yes. This 2014 matter, madam. Huh? On the prayer of Miss MS. Learned counsel appear on behalf of Mr. M.K. Sharma, learned counsel for the petitioner. Place this matter after 2 weeks so as to enable the petitioner to file their so as to enable the petitioner to file affidavit in reply. Yes. One nine. When? It's a new matter. Why? What is the urgency? Subsistence allowance. There's no urgency. It will listed in its own turn. When do you want? When do you want? 2nd September. Yeah, listed. We'll see. Next week. Next week.
34 days. Isn't it money? Cannot test it. But that is look at the respondents and councils.
So, are you holding the matter? A brief. Have you not prepared the case? If you are prepared, we'll hear what's there. On the prayer of no, Mr. S. Nath, learned counsel, admits that he has been recently engaged as a counsel for respondent number 1, 2, and 3, for which he may be granted a week's time to go through the brief list of Mr. B. Phatak, learned counsel for the petitioner, raises no objection. However, submits that there are other analogous matter pending. Therefore, these two matters may be listed along with 27117 of 2022. List of having considered that the Mr. Nath has been recently engaged, come up. Let this matter be listed after a week, after 2 weeks. After 2 weeks, along with WPC so and so. Interim order passed earlier, sir. Continue.
What does that inform? Hearing item 6.
Why orders? Okay. Okay.
Item 6.
Timing.
Timing.
Possible.
P7.
Hmm. Ah. You have maintained proper account. There is a direction to maintain proper account of the sales which you have received. Hmm. So what is to be done? No, apart from that, suppose if this court, even if alternative remedy is if this court hold that you could not have collect the cess, then it depends on case to case facts of the matter. Otherwise, you're wasting use. Now, from 2017, it's no longer there's no longer cess is not being collected. No, before that only this court has directed you to, huh? No, that will be very difficult, sir. That will be difficult. Where it goes, once it is collected, where it goes. Just because the gates are closed, you cannot. It's a public money. If a cess is collected, it's public money only. Whatever is there is a direction to maintain the proper account. What is to be done now? Huh? It's a part of matter, sir. Saying what? Huh? One page is this writ appeal 288 of 2018. One page, second page is missing. There's a blank. Second page is blank. Where is the judgment of the single bench? Hmm. Otherwise, on merit, the petitioner is correct. On merit. Division bench has upheld the decision of the single bench in Tinsukia. But then only the refund has been interfered with because there was no, what do you call? There is no details of refund has been indicated. Can you inform the other side? We'll dispose of the matter. What's there? That will be, in that case, it will be academic only. Because the on merit, I mean, you could not have collected cess. Otherwise, also, but then they have already paid the cess. Where it is? Where it is? Yes. We'll see. We'll close the matter. There's nothing remains. Although the learned counsel to the response is fairly submitted.
Okay,
Timing, whole timing. Hmm? Hmm. Yes. Yes. That is the same submission last time. This was passed in the month of May, June, July, August.
That second project, one, first, then 29, 29, 5, the third one. Answers given to them on first of May. Same ground, I get it after also.
What you have written? Let me see your communication. Last communication, not all the communication. Since the compensation has already been deposited, you pay. You have to pay. Although you have said that no money has been deposited, but then they have said, yes, yes. It's a third tab. We have given you a last chance on 29/5. Right. Add Mr. Swenson, counsel for the petitioner. Although the Leonard State Council have been granted many have been on many occasions, Leonard State Council have been granted a time to obtain instruction and and last being order dated 29/05/2025, comma, considering the nature of considering the issue involved, let this matter be listed on Friday 29 2025. On the next date, no further adjournment will be granted, even if no instruction is placed by the Learned State Council. Whatever you want to do it, but we'll direct you to pay, or else we'll call the concerned officer. You find out the name of the officer at that point of time, Deputy Commissioner. None appears for the petitioner on call. Next para. On 13/05/2025, Land Council Mr. A. Khalek has sought for the time to go through the records as the counsel for the respondents. No. None appears for the petitioner on call, huh? Next para. Mr. J. Khalek, counsel for the respondents on 13/05/2025 had submitted that leading counsel Mr. A. Khalek has expired. Therefore, no, let us not had submitted that in view of the submitted that leading counsel Mr. A. Khalek had expired. He needs some time to go through the records, and accordingly, matter was adjourned for 4 weeks. Please stop. Today, when the matter is taken up for hearing, none appears for the parties. Please stop. Considering that the matter is of 2025 and the parties may not be interested to pursue this matter, let the writ petition stand dismissed for non-prosecution.
Item 25.
Yes. Withdraw. Okay. Otherwise, it's become might have become infructuous. Withdraw. Okay. Mr. Arshad Land Counsel by the petitioner submits that he is an instructor to withdraw these duties. Please stop. Accordingly, writ petition stands closed on withdrawal.
26. Item 26.
Yes. This is the last matter. All other 2 matters have already been passed over for time being. What is the matter? What is the matters, madam? Yes, sir. Respondent. Where is the award? Impune award.
Page 158.
158.
Page 12 of how it's loaded by
Yes.
six, for how the
Hmm.
that coaching lockout and trying was much document and probably 50% time we will for the daily
Hmm.
just give people your
Hmm. Hmm.
taking the element statement whereby maybe a point
Hmm.
and then you get the one for all the just that you have to keep.
Section.
Section K, here government required to maintain a fund
Hmm.
by SEBI, the transfer payment.
Hmm.
Case. Where the associate government, the associate government, maybe the central government, or the state government. Is of the opinion that any intellectual disputation or every element is made at any time by order in writing, refer the dispute before or promoting the settlement there
Hmm.
is not relevant for our cases.
Hmm.
Refer any matter appearing connected to the relevant dispute to a court of inquiry. It is also not relevant for our cases.
Hmm.
C, E and D version. Refer the dispute to any matter appearing to be connected the relevant the dispute which relates to any matter specified in the second schedule of the labor code or adjudication.
Yes.
So this matter was referred to the labor code for its adjudication.
After 7 years.
So great, and it has to be referred by the advocate government, not by the, not by the party concerned. And gateway approved the labor.
Ah.
It has to be
Refer dispute any matter appearing to be connected with relevant to the dispute, whether it relates to any matter spelled in second setting or third setting.
now
Tribunal for adjudication, yes.
now the procedure. That purpose we are going to come to the function of section 12 of the industrial. There is a procedure, provision for conflict.
So this has been, your case is covered by C. 1C. 1C or 1D? Labor court, not to the tribunal. So,
Matter to be confirmed the labor group and one and
anyway, but then your case falls under this.
yes.
1C. 10 1C. Yes, then
When the market reference
section 12.
section 12 yes. Section 12 when a dispute is raised, dispute occurred between the management and the workman, then this, it is the conciliation officer who will try for a second. There is a now, where any dispute, industrial dispute exists or is apprehended, the conciliation officer may, where the dispute relates to a public utility service and a notice under section 22 has been given, shall hold the conciliation proceeding in the prescribed time. You can try to settle the dispute between the parties. The conciliation officer shall, for the purpose of bringing about the settlement of the dispute without delay, dispute the dispute, all matters affecting the values and the rights of right, settlement thereof, and may do all such things as he thinks fit for the purpose of inducing the parties to come to a fair and equitable settlement of the dispute rights. Now, if the settlement of the dispute or the matter in the dispute is arrived at in course of the conciliation proceeding, the conciliation officer shall send a report to the appropriate court. Or the officer authorized in this period by the appropriate court, together with the memorandum of settlement signed by the parties to the dispute, to the matter is settled. And if it is not settled, then what is it? That is section 4. If no such settlement is arrived, the conciliation officer, as soon as practicable after the close of investigation, sent to the appropriate government a full report and setting forth the steps taken by him for ascertaining the facts and circumstances relating to the dispute for bringing about a settlement thereof, together with the full settlement of such facts and circumstances and the reason on account of which, in his opinion, settlement could not be enacted. Here, he has submitted a report to the appropriate government. Now, if one considers the report to the subsection 4, the appropriate government is satisfied that there is a case for reference to a court, labor court, tribunal or national tribunal, it may make such reference where the appropriate government does not make such reference, it shall record and communicate to the parties concerned the reason thereof. So only after consideration of the failure report, the appropriate government shall refer the matter to the appropriate court, either in the labor court or in the industrial tribunal. If the appropriate government is of the opinion that it is not an industrial dispute, then we shall communicate the matter to the agreed parties and the reason thereof. A report in this section shall be submitted within 14 days on the commencement of the conciliation proceedings or within such shorter period as may be by the appropriate court.
Sir, why you is referring to this?
Because of the pointed out that 7 years,
Ah,
the appropriate government made the request of a long period.
because there's a proceedings as per section 12. There was a proceedings. So therefore, there is no question of delay and there's no prescription of time limit. There's no limitation. The moment the conciliation and other things, mediation is over, then only appropriate government, without there being any specific time limit. That is your submission.
Now, then you will come to section 10.
Ah.
Now, again, section 10. Right. Where the appropriate government is of the opinion that any industrial is legit or is apprehended, it may at any time by order in writing, refer. That is so. So appropriate failure report, so what a failure report is concerned, the appropriate government shall have to consider whether it is an industrial dispute or not. If they have the opinion that it is an industrial dispute, then and only then will the appropriate government.
Provided also that no proceedings before a labor court tribunal is shall lapse merely on the ground that any period is penal. Yes.
Now, look, the dispute is concerned, it is pertaining to a matter which is called as lockup. So, yeah. The working may come to section 2L of the industrial dispute, like the lockout is. Lockout means temporary closing of a place of employment or suspension of work or refusal by the employer to continue to employ any number of persons employed by.
Hmm.
Now there are certain restrictions because of the lockout and strike. Similarly, strike is also a weapon of the worker. But so if we come to the position for the strike, section 2Q. Right.
Yes.
Strike means a cessation of work by a body of person employed in any industry acting in connection, combination, or concern, refusal, or a refusal under the common understanding of any number of persons who are or have been employed to continue work to accept employment.
Hmm.
So these are two words. One is with the workers and another is with the employer.
Come to section 24.
Now, section 23 and 24 are there.
Hmm.
Twenty-two, 23, and 24. Let us see.
Hmm.
You first.
Yes.
Now, 22 are the difference. No person employed in any public utility service shall go on strike in case of contract without giving the employer a notice of strike as hereinafter provided within 6 weeks before the striking or within 14 days giving of such notice or before expiry of the date of strike specified in such notice as aforesaid or during the pendency of the consultation proceeding before the consultation officer or 7 days after the conclusion of such proceeding. So if there is any dispute pending before the consultation officer, as I have pointed out to the Lord, as contained in section 12, the parties to the dispute should not resort to lockout or the strike during this conflict.
Without notice.
During so far AAPC is concerned, it's not relevant because our topic is not public activities. Clause 2. No employer carrying in any public utility service shall lock up any of his workmen without giving them a notice of.
This is not relevant. This is not relevant. Public utility. It's not a public utility.
So the only thing is that during pendency of a consultation proceeding or pendency of any proceeding before the labor court or the industrial tribunal, as the case may be, the parties to the dispute should not resort to a lockout or strike. Now, This constitution is at least a second. Now, general prohibition. Now, you have to come to section 10, let's come to section 22.
Hmm.
General prohibition. Strike and lockout. There's a special prohibition. Which it is concerned. General prohibition is that no workman who is employed in any established industrial establishment shall go on strike in breach of contract, and no employer of any of such workmen shall declare a lockout during pendency of the consultation proceeding before a court and 7 days after the conclusion of such proceeding. B. During pendency of the proceeding before a labor, that is what I just called for, a labor court, tribunal or national tribunal, and 2 months after the conclusion of such proceeding. Third, during pendency of the arbitration proceeding before the arbitrator, and 2 months after the conclusion of such proceeding, where a notification has been issued by subsection 3A of section 10A. So there is a proceeding for arbitration also. So if you request both, I can do.
This is during when?
Yeah.
When was lockout? When was the lockout? In this case, when was the lockout? Was it during the pendency of the
During the pendency of any proceeding.
either conciliation or arbitration? Nothing.
Now, only this thing is that labor court has to examine whether the lockout is justified or not.
So read section 24. Let us read section 24.
A strike or lockout shall be illegal if the comments are declared in contravention of section 22 or section 23.
Hmm.
And it is continued in contravention of the order made by under subsection 3 of section 10 or subsection 4 of section 10A, where a strike or lockout or the industrial dispute has already commenced and is in existence at the time when the reference or the dispute to a court or arbitrator or labor court tribunal, confidence of such strike or lockout cannot be deemed to be illegal, provided that such strike or lockout was not at its commencement, contravention of the provisions of this act, or convenience thereof, and was not prohibited under section 3 of section 10 or subsection 4 or section 10. The approved government may can prohibit some certain strike under section 10 subsection 3. When a dispute is referred, then the approved government can make a notification. The effect that most government lockout to be that is what contrary section 10 subsection 3 as well as section 4 of subsection. So all these things are there. That apart, don't basically
You read the main subsection 3. Read subsection 3. 24. Section 24.
declare in front of illegal strike or illegal considered illegal lockout shall not be deemed to be illegal.
A lockout declared in consequence of an illegal strike. Strike declared in consequences of illegal lockouts shall not be deemed to be illegal.
So that is because by the very
No, what they're saying is that since the lockout was consequence to the illegal strike, the labor court could not have had a findings that the lockout was illegal. It should be legal. What they're saying is labor court has not applied this provision. What do you say? You have called for a strike. Consequence to that, according to them, the strike was illegal. Therefore, lockup could not have been illegal. As per subsection 3 of section 24. That is their case. Appears to be correct.
Well, I was from, for,
Hmm.
on the.
Hmm. Enter. No, you just try to justify this. If a lock or if lockout is declared in consequence of illegal strike, it shall not be illegal. So you have to demonstrate the strike was not illegal. It has followed the section 22, 23. That you have to show. Hmm. Hmm.
Taken the individual program to fulfill the charter of demands. The union has also brought that at the instance of the management, a different union was formed with the name Assam Carbon Staff Workers Union. And the union, namely Assam Carbon Staff Workers, Assam Carbon Workers and Employees Union was not present in the meeting, and no memorandum of settlement was signed by the Assam Carbon and Employees Union. This fact was held during the evidence by the union before this court. Against this fact, management has not advanced any complaints. The union's demand was regarding the weight and condition of service of the worker. The management plea is that even before and after the execution of the management, the execution of the works carried out requiring educational program in support of their aim, it is seen that the management did not try for the group as to provide to workers by continuing their educational program. And even after execution of memorandum of settlement, the management feel that they had the representative workers attended the meeting and they signed the MOS before, therefore, the workers had to follow the conditions laid down in the MOS, memorandum of settlement. It is the plea of the management that the workers had also resolved a program of fourth floor. Management witness number 2 is none but the advisor, finance and accounts of Masses and Assam Carbon Private Limited Equity One 26. Stated giving the evidence that no statement or report has been filed. Statement or report has been filed before this court show that the company was suffering loss. Between 5 and 86 letters issued by the cabinet ministers issued issued to the cabinet ministers of government of Assam. Exhibit 5 is addressed to the Minister of Labor and Employment, Mr. Tikki Maji, government of Assam Dispute. And exhibit 6 is the letter to the Minister of Industry and Commerce and Power, government of Assam, Mr. Potu Bandale. The two letters are said word by word. Though the said letters were informed to the government of Assam that the management of the company was of serious doubt whether the plane or the plant in Guwahati would be able to continue operation due to unreasonable hostility of the productive health and welfare department, therefore, the management sought help of the police and the district administration. It has not come to manage, it has not come that the management had taken initiative to resolve the additional program at early. The management for the rate-based greater interest of the property.
Because on the last petition, my lord, the matter is before my lord Justice Nair. I think the petition started arguing, he was not present, and he made a vehement objection.
Mm.
That how come in his absence, I'm asking this. The same stance put for him also. You are told to become. No, that's very unfortunate, that's not true.
No, right, but I do. What?
No, no, actually, my difficulty is,
It's a sweet revenge.
what is, put for him is also put for me. No, I think I'm sorry, not the difficulty is, in vote number 5, there is a 2015 piece. And another added difficulty is, my lord, the petitioner happens to be R.H. Lama.
Mm.
I don't understand my difficulty. He's keeping the watch, very, very old man. So, my lord, and if I wanted some accommodation in the meantime, that matter may also. So, because this case may take a long time, I'm prepared otherwise.
Mm.
I'm completely with them.
Mm.
But it will take, quite some time.
No, while waiting for you, I mean, I just asked him, let us go through it because this is the other two matters. Other two matters have been passed over. So this is the last matter. So I just cannot go away again, come back. Hmm. Hmm. It's okay. Yes, some difficulty in that case. Next week. Okay, this is also 2019. In fact, I have read your brief, your grounds, everything. Now the burden on him to support the award. So anyway. On the prayer of Mr. P.K. Tiwari, learned senior counsel for the petitioner, and the prayer not being objected to by Mr. A. Dasgupta, learned senior counsel for the respondents. Come on, let this matter be listed after a week. We'll take up after a week. 18th September. So 3 weeks. In that case, 3 weeks. On 18, 3 weeks, and then I think 18 will be 4 weeks. 3 weeks. 3 weeks. Fourth of September, we have fixed so many fixed matters. 3 weeks on 18/09/2025. No, that will be difficult. I'll be taking other matters. There's one. 18, huh? 18. Huh. 18, huh? Huh.
Big 6.
Six. What is there? You have retired in the year 2014, 15. Huh? How many days? It's a parlor matter. Then you have sought for a term. That is on 5/6, 2 months back. Yes. of filing affidavit. It's okay, you argue the matter, we'll hear. What is there? You are seeking a promotion, which you ought to have been. For how many days, years? 3 months. You have retired after 3 months. What next week? There's nothing. Yes, what happened to those recommendation? Let us see. We just wanted to know that recommendation. What happened? No adjournment. This is final disposal. It's a part hard matter. You just show us what happened to those affidavit in opposition by whom? Respond number 2. Yes. Show us. You just show us what happened to the incident company Baxter State Municipal Selection Committee indicates that the against board member will be in the rank of joint secretary following deputy were recommended for permission. 13/3/2013. 1, 2. Your name is not there. Sri Koila was a promoted joint secretary against clear vacancy that is in 33 and he retired on 33/2013. Yes. Not required. We wanted to know the what happened to those the recommendation. You have seen the affidavit. They were recommended 2 persons, including you, including the petitioner. But the other person who was, given retrospective promotion, then he was promoted. And thereafter there were some vacancies. But there could not be any the selection committee. No, it's not. No, that is what they are saying. See, following the retirement of Sri Bhupendra Dipsisma, however, could only have been filled up by the recommendation of the selection for the year 2014. But due to certain procedural exigencies as elaborated in the resolution, so filed in the meantime, the petitioner retired attending the resolution. It's okay.
Yes, for 1 year, you would also be kindly see people who you would also be kindly see what they say, and before that, you would also be kindly see that you would also this letter from It petition your lordship page 17. Holding of selection committee boards meeting and preparation of agenda there.
Page.
Page 17. Your lordship, on the holding of selection committee, your lordship, why this is they have done, made the selection, your lordship will kindly see. And then your lordship.
Holding of selection committee boards meeting and preparation of agenda. Yes.
Very.
What is this?
To recommend select list to officer persons for promotion to the next higher profile provided. Order is not taken, as a result, the eligible officers are deprived of getting the benefit in time. It has also been observed that in many cases, department do not furnish the relevant documents for purpose of holding selection committee board, particularly the ACRs as required. Instead, in certain cases, special reports are placed in other cases, nothing as such is from the argument is preferred that since the concern of the persons who are in due promotion are not responsible for no liability to ACR, this should not make suffer for want of ACR. Why this project officer's concern should not be made to suffer, it is equally to consider concerned department of the responsibility to obtain ACRs since ACRs which have to be written this code. And then your next paragraph. It is compulsorily part of administrative heads of department to ensure availability to ACRs before the selection of the board meeting is fixed. The concerned according legal absent officer should be made responsible for not according legal ACRs with some service confidential group. In absence of agenda rules, that paragraph plus next paragraph in page 18. In view of the circumstances set above, it is impressed upon all concerned that every endeavors to take an advance action in time so that the selection committee boards meeting are held timely to recommend select list of officer and persons for promotion to the next higher post, and all eligible persons are allowed to avail of the benefit of due promotion and that. Now your lordship will kindly see my affidavit in reply also. Where we were selected.
Where it is?
Page 34. Of my affidavit.
Page 34.
Joint secretary, deputy secretary. All total suite of vacancies in the cadre of joint secretaries are filled up by way of promotion from deputy secretary. As per notification number 7, there is no eligibility criteria on the length of service for this purpose. The matter regarding applicability of reservation in the cadre of joint secretaries discussed, it has been observed with Honorable Guwahati High Court and its judgment that it treated 2007 in WPC number 7, so rule that for cadre constituting on its portion. Regardless cannot apply. The selection committee accordingly noted issue. The selection committee went through the records of ACR. Of the 13 numbers of eligible deputy secretaries who were under the zone of consideration and recommended the following in addition to the four numbers of deputy secretaries already recommended by their meeting dated 13/2013. Srimati Samik Samswa and Rohit Bhatt. She Samik Samswa is entitled to benefit first. First you will be given, then my turn will come. There is no requirement to hold a fresh selection.
What does it say? What it says? The total numbers of vacancies in the cadre of agency are to be filled up by way promotion from deputy secretary. As per notification, so there is no criterion. But he went through the ACS of so eligible. 13 numbers of eligible deputy secretaries were recommend the following in addition to the 4 posts of already recommended by
Samik Samswa, Rohit Bhatt. These are the two.
this is in addition.
In addition, Samik Samswa University was to get the appointment promotion first, then me. Next page your lordship will check. This Samik Samswa is entitled to get the promotion and benefit first.
Is now seen.
First, as he is now senior was deputy secretary after getting respective promotion benefits by notification number so and so. So there is no requirement to hold a fresh selection, your lordship. What they have to do, your lordship, that is what they have also admitted, your lordship. Your lordship will kindly see. If Bhupen
No,
wishes-
when this was recommended, you were recommended, there were only one post. After that, only another post fell vacant.
Bhupen Bhakan.
Therefore, there should have been another recommendation. Not appointed. There would have been a selection committee. What does it say that there are two next vacancies she will be promoted? See, at that point of time, there was no vacancy. Only one vacancy was there for joint secretary. Then subsequently another post fell vacant. There could have been the selection committee. I understand, but that has been somehow it has not been done.
They have no, there is no requirement.
Sorry.
They want to promote me, your lord. That is what they have.
You are trying to say the promotional benefits first, as he is now senior most deputy secretary after getting retrospective promotion. Yes,
My turn. And your lordship.
your turn will be, considered. You will be considered after next election.
No,
On
that's what I am.
what does it say that in future vacancies you will be promoted? See, there were only one post at the relevant point of time. That's why this Sensua is found to be a senior most.
The action is paid for your vacancy also, your lordship, for promotional.
What does it say?
Your lordship, that has procedure. They have not denied it. What they have said, your lordship, will kindly see in their affidavit. Let us take it. They have not said that there is requirement to hold a fresh selection.
It is
Have to come up
no.
immediately.
See the same analogy regarding the vacancy. Suppose if it's a direct recruitment, sir. If it's a direct recruitment, then the moment it is, the next will be there will be a second, further advertisement or recruitment. Same analogy for promotion. It doesn't say. They have just said that since Sensua was senior to you, therefore he should be given the first. So there at that point of time when recommendations were made, there are only one post. So next subsequent there I understand there ought to have been a selection process for filling up. But unfortunately, you have retired before that is done.
They recommend this, that's why I have showed that.
Hmm.
They recommended it for future vacancies also. That is why.
What does it say?
There-
When referring to these benefits first, then show us that in future vacancies she will be considered. Yes.
recommend my name, then your lord. Then my name would have come under your.
See, there cannot be a recommendation of only one.
There can be.
Two were recommended, and it has been clarified since Sensio is senior to you, he would be senior to you. First, his case will be considered.
There is.
I've seen that. Latest one. Para 9, I've read it. You read it. You read it, please. I have read it. You read it, please.
The answer. That the really recommended the meeting. Bhupen Saikia was retired on 31/7/2013. That's he is already over. Moreover, during the year 2013, there was no vacant post of joint secretary to accommodate the petitioner. The subsequent vacancy in the cadre of joint secretary arose only on the 31st January 2014, following the retirement of Bhupendra Goswami. This position, however, could not only have been picked up for recommended to the committee for the year 2014, but due to certain procedural accidents as elaborated in paragraph 6 of affidavit in section 5 by the respondent number 3, in the meanwhile the petitioner retired on attaining the age of supervision of 31 2014. And this is where your lordship, my submission is this is not correct position of what they have said, your lordship. And that I can show from your lordship by bringing in the your lordship the previous lordship selection committee procedures. I can bring it. That's why I am submitting your lordship that my the petitioner your lordship here 10 years have already elapsed, now 70 plus your lordship, so it is not well, that's why they do not come down your lordship.
No, no, last procedure, we are not interested.
So
You saw that the as per the last the recommendation, the case of the petitioner shall be considered for permission by the selection. It doesn't say anything.
Since my claim that has been followed, your lordship, I will have to be allowed to bring those documents, your lordship.
What will not concern. Earlier proceedings were there. There's a selection process. Your name were considered and recommended, but since there was only one post, number one was given, considered, and promoted, and thereafter, just before your retirement,
See, this based on that one after another is made. Your lordship will kindly see from there. Had they secured your lordship, had they held press advertisement for every select promotion your lordship, they have annexed all these, your lordship will kindly see. They have appointed your lordship. This is P 2013. Then your lordship. Then 20th July 2013, the appointment of Somi. Then your lordship 20th September 2013, July, August, September. Then he was promoted as joint secretary. Your lordship will kindly. These are on different dates, your lordship, they have your lordship promoted different persons to joint secretary, your lordship, from the one list, your lordship. As party, your lordship. Recommendation, then your lordship.
So you have filed this writ petition after your retirement.
Just before my retirement.
Huh?
Before my return. Then your lordship, 20th December 2023, Mantri Dr. was your lordship temporarily posted as joint secretary. If they can show that for each appointment, they have held different your lordship selection process, your lordship, for promotion, then your lordship, the same will applicable to me, your lordship. That is not their case. That is why I am submitting your lordship. Give me some time, your lordship.
No,
I will bring.
it cannot be.
Your lord.
Whatever you want to argue, you please argue.
What my case is, unless your lordship allows me, your lordship, let them then produce from recommendation for this person, your lordship.
No, no, we understand there was a selection process and for some other additional secretary, and there was a selection process. Unfortunately, there could not be a selection process for this post, which you are, the present post which you are claiming, right? Just you think about it, it's just a matter of 3 months. Unfortunately, you had to be retired.
But your lordship,
We understand during they could have considered your case the moment it was the post fell vacant, but then it could not be done.
that your lordship, that
And it's not, so was the rule, the moment it has to fill up, except from this advisory. So was the rule. How many days it has to be considered, within how many years? I mean, days or months. After the post fell vacant, after how many days it has to be filled up? Is there any specific rules? But what we understand is within 6 months or once in a year, it has to be, there should be a DPC or selection committee.
for 1 year, you will always remain condition.
It doesn't say, unless it is specified. It's not a rule. Wait list.
That's still the problem.
If it is a problem, then we can't help it, sir. If there's no provision under the rule, we'll go by the rules. You show us any rule.
Fine.
Then we're hearing you. We're hearing you. We'll complete this today.
1 second.
We have enough time. You go to, kindly go through it, argue your matter.
The current concern the problem that they are not saying anything about the promotion.
If it doesn't say anything, then what can we do? Can you create a rule? Sir, can we create a rule?
This is a factor to be considered, Your Honor. Past practice is this, Your Lordship. They recommend, Your Lordship, name, series of names, Your Lordship. Based on that, Your Lordship, vacancy arises, they were appointed, Your Lordship. That's, and once that's completed, then, Your Lordship, they go for the press selection, for the promotion, Your Lordship. They have also not.
Which rule you are relying that which regulates the promotion to the post of,
Anything on that?
what is that rule? Let us see. The service shall consist of the following three categories post: deputy secretary, under secretary, superintendent. It doesn't talk about the joint secretary. So this rule is for these three categories of post: deputy secretary, under secretary, superintendent.
That is, Your Lordship, I am deputy secretary. My promotion is next scheduled to be, Your Lordship.
Who is questioning your the position as a post as a deputy secretary? You are claiming nobody is. You have retired. It doesn't govern, sir. This is for the secretary, deputy secretary, under secretary, and superintendent.
There is only one notification, Your Lordship, 14 February 1995.
Yes.
Is there. It says the governor of the please to order that there shall not be any eligibility criteria on gain for service, as has been stated therein, for the purpose of preparing a select list from amongst the deputy secretaries included under the Assam Secretary Service 1963 by the selection committee constituted by the government for promotion to the joint secretary.
Where it is?
14th February.
Yeah. Last part short. 14 February 1993.
All the under secretary and superintendent under secretary service who have completed 2 years of service in the classificated in the first year of the selection committee is held with a fixed mandate of where it is? 14 February 1995. Where you are reading? Second para. It's first para. Where it is?
You can take this.
Oh,
I am for therefore.
there shall not be any eligibility criteria of on length of service for the purpose of preparing the select list from amongst the joint secretaries recruited under the Assam Secretary Service. By selection committee constituted by the government. I don't know.
Find or from their applicant.
So 1963, although it doesn't mention about the post of joint secretary, by this the notification, it has been clarified and included. It is inferred to be included as per Assam Secretariat rules.
Please, there, they can. Not for. Please for.
Give him back. It's here.
Please for.
Hmm. Page 42. Yes.
Thirteen, 2013 year old.
When this post fell vacant?
Maybe
14, 14. 14, huh? You retired on 31-3. Hmm.
then your work can become eight for a month.
No, this has been explained.
So, on
Hmm.
almost of the- it is- one euro, it is 13,013.
Hmm.
And mine was in it is 27,613. Which takes a complete. Now you are also doing fine. Yeah. The sector committee going to be record of SCR of 20 conversion. Under the zone of consideration. Then recommending this remaining need number of specific categories for promotion to the post of joint secretary. You are also doing fine, you will also need numbers of names. The topic is fine, you will also need numbers of names. This combination and fees 42, 8% were recommended.
Hmm.
Now you know also will time this serial number 5, Sri Gulo Ram Deka. Now you know also will kindly come to page 56.
Hmm.
Phase 56 fellowship mechanism.
Hmm.
That was dated 20th September 2013.
Hmm.
On that day, your worship, Gunaram Deka was promoted to the post of vice
Huh.
chancellor.
So,
Then your worship can come to next is on December 20th December 2013.
yes.
That means your worship, after 3 months, she was promoted from the one selection list. There was one list from which all of them were promoted. I am showing this to Arjapon Board that your worship, since the procedure they have been followed. One selection list, recommended certain names, the moment post will be taken, they were promoted. And
Well-
that is why your worship, each of them were promoted on different dates, your worship.
It's a different then, but then there must be something
That is why.
before it is unless it's clearly shows that the selection committee has considered for the anticipated vacancy or future vacancy, it's very difficult, sir.
Aspects, you know. And that is why I'm stressing on that. When the rules are silent, your worship, you will have to depend on the past practice they have been followed. And past practice has been held by the service courts, your worship. That sometimes your worship that will have to be accepted. And that is what they are doing. So when you are doing this again in respect of other employees, your worship, other officers. you are
No, first practice doesn't mean that it is as per, if it is as per the rule.
silent, what they will follow. They will have to follow certain practices, and that is what this is, your lordship. Now, your lordship will kindly see, this is absolutely discriminatory and arbitrary so far as petitioner is concerned. You have appointed, you have promoted certain person based on a select list, your lordship, by step, and when my turn comes, you said that there will have to be a press selection process. That cannot be, your lordship. That will be arbitrary. That cannot be two standard for two sets of employees. Your lordship. That itself will be arbitrary. And your lordship will kindly see at the end of the day, I am at their mercy, your lordship. It is their due. Honorable Apex Court has held the right to consideration for promotion is a fundamental right. Then where have my fundamental right has gone? They have failed in that respect. And for that, your lordship, should I be penalized, your lordship? I would have get your lordship what I would have got. I would have get your lordship some more pension after my retirement. More than that, I would not have been benefited anything more, your lordship. That's why, your lordship, my case is that, your lordship, it is therefore, is or therefore, is it me to be, your lordship, punished, your lordship? Then, your lordship, if that can be the ground, then we could not, your lordship, that we could not help due to certain exigencies, your lordship, then they can help do it for each of the, your lordship, employees, your lordship, whom they don't like, your lordship. That can also take place. These aspects, your lordship, cannot overlook by saying that you have retired already. And in fact, your lordship, honorable Apex Court has held, your lordship, in one case, your lordship. One of the principle of service is that any rule does not promote the duties of the employee for the service prior to whether immediately the vacancy is which appears for promotion and offered prior to inspection of the post. The partner of this area of the post was class for employees could be promoted to a full prior to August 2019. The selection in respect to the ticket service of the job started prior to August 2020. The department would have proceeded with the selection well within time and would have completed it before August 1983, then appellants would have become ticket collectors without any difficulty. The mistake or delay on the part of the department therefore should not be permitted to recoil on the appellants, your lordship. Now, if your lordship does not, your lordship, interfere in any manner, your lordship, then your lordship, it will be punishment will be on me, your lordship. It will be recoiled on me, your lordship. Although there is no fault on my part, your lordship. Another husband, your lordship. At about a month of your lordship. What the board of the 2010 4 790, there are 35 and 36.
Yes. Hmm.
State your lordship must keep in mind for national obligation of both the appellants and central government, also the state government. Both the central government and the state government are to act with a model employer, which is consistent with their role in given press. Then 36. It is an accepted legal position. The right to be of eligible employees to be considered for some to be part of their fundamental right guaranteed under Constitution. The guarantee of a fair consideration in matters of promotion under Article 16 virtually goes from the guarantee of equality under Article 14 of the Constitution. Then your lordship, that is so your lordship, the non-consideration. Before, in spite of there being vacancy, your lordship, in spite of.
It's a matter of 3 months only. How long is selection committee is required to be reconstituted?
The fundamental right, for consideration. There cannot be way, My right,
It's इतना गर्म क्यों दे रहे हैं? Normal देखो, normal.
The code of it, if that view is probably that would not be your lordship, so far as the citizens are concerned, your lordship, that would not be. To their. When the tax code is held, if you have fundamental right, you know, the essence of fundamental right, you know, then you will not see any, your infringement of that right, you know, call for this honorable court to, your intervene and give justice to the citizens, you know. And admittedly, they have failed in their duty, whatever it was. The excuses they have taken, your lordship, I would have retired as a joint secretary. I am not paying anything over. What I am paying over the notional payment. That's it. But I will get your my pension will be fixed at slightly at a higher rate. More than that, I will not get. Notional is not for a contribution right now. Right, considered is there, because considered by the state kind of retired.
Before her retirement, there was a post, the post fell vacant. One more aspect, in other, the recommendation, you have appointed those persons again when post fell vacant. Her name was also there. No, not that. After that, there was a recommendation, one censure and a petitioner. Since there was at that point of time, there was one post, therefore censure was promoted. Now, before her retirement, there was the post fell vacant. See, if she is considered and found to be fit, all right, and not been promoted, then in that case, you may say that it's not a matter of right promotion. She has not been considered. That is the issue. No, an affidavit is required. No. What is the? Call him. We'll hear him. It's okay. Cannot afford to keep on. Call him. We'll take it up at 2. Call him. We'll take it up at 2. No, today. Hmm.
Having said it,
Yes, he has fairly submitted that on merit. He agreed. The cess could not have been collected from you. But in view of the judgment of division bench in similar matter, division bench has said on merit, we agree. But then since there's no details of the account and that thing, the refund was interfered with, or a direction to refund.
And then pay to the government. So actually, it's not going from my pocket. So it will amount to unjust and it will be returned to me. I will not return to them. This is the reason why the division they is not paid from your pocket. You collected it from somebody and then you paid. So I will not, you are not entitled to get the refund. But insofar as this case is concerned, this is a bit different. I will just distinguish this case. Firstly, Lord, you can kindly see the interim order which was granted.
Yes, I've seen.
Secondly, Lordship, we kindly see my affidavit. My affidavit.
It's a similar matter. Same thing.
Only one thing I will show. May kindly see my affidavit. Kindly allow to argue. Can you shut down after I will be.
Page. Page. Where it is. 380 is something else. In case under trading and then dealing excluding vegetables and fruits shall not be necessary to pay. This 380 is something else. Yes. You said there is 390 to whomsoever it may concern. Dixis Dattaraya and Dattatreya and associates. We certify that the price recovered from the distributor is not inclusive of agriculture sales. The sales paid debited to P&L accounts and not. If under certified, we have not paid agricultural sales to Maricoland on purchase of parachute coconut oil from.
That is why, Lordship, when the case was, the court said that whatever tax you have collected, you will keep an account of the same. And then report it immediately when the final, at the time of final. We can see the last paragraph. Respondent will keep proper account of cess yet of the petitioner company so that in the event of petitioner succeeding.
No, it said the following the interim order passed in the, it is provided the respondent marketing will keep proper account. 4469 is what? 4469 is taken to appeal. Just wait. 228. So in view of this order was passed, in view of the interim order in 4469, which has been allowed by a single bench and taken to appeal where the refund was interfered with, direction for refund was interfered with. And this to keep proper account of the sales related from income so that in the event the petitioner succeeding in writ proceeding, the board can immediately having regard to something, yes. This interim order was on the basis of the interim order passed in that 449. That's what I'm saying. That is the only the difference we are trying to project. Otherwise, merits though no issue. He has fairly submitted that on merit, it has been settled. It has been settled, right? So the sales could not have been collected. Huh?
On this record, the balance of this one, tell them, Krishna has not paid any sales to the base in Jaffa. As such, the compliance of the order can take a present definitive velocity for maintaining a separate proper account with regards to the Krishna was not as. They have not paid this after December.
This order was of which year?
So,
2017. On scrutiny of records, the collection of cess from the petitioners revealed that the present petitioner had not paid any cess to SM after December 2016. As such, for compliance of them. For which period you are claiming?
said that what they have said was that they said that they have paid the tax to the check it, not to the board. They collected from the check it. How can when will I get the time to go to the board and pay the?
No, no. They are saying that after December 2016, you have.
Assam.
Directed the national people. In this connection, it is that the government was by directed collection of check it what total stuff. No, that's why I'm asking. They're seeking refund of. I mean, the collection from 2002. We may understand after 2016 there may not be any. They may not have paid it. Which year? Till 2016. After that, there's no. So their claim is from the day one till they paid. Huh? No, before that, we'll come to that. What they're saying, what the petitioner is saying that they have been paying the cess since 2002, right? In the gates. Whatever. You just saw which period indicate? Which period? Year 2000? 2000? 2017. In the gates were closed in December 2020 or January from 2017. Ah, 2000 Maricon in this regard, it is the government of Assam might notification directed concern to.
Even 17 to 20 we paid to the check.
It was withdrawn. It was withdrawn in the 31st July 2017. Let us see page 82. (2004) This is your, prepared by you only. Total is how much? Huh. Now, what she has submitted is that in Tinsukia matter, the petitioner, they have collected from the end user. Here is a case they have not collected. There is the certificate, 390 certificate is there. Page 390 by the chartered accountant and the end user. All right. So this is the difference. That is what you tell us. It's all right. It can be if we direct them to the refund. You can verify. You can verify, but main issue now is she has projected that there's a difference because in those cases where the division bench is interviewed with the direction for refund, they have collected from the end user, right? Here is a case they have not collected, they have paid from them. To support that, he has given this annexer, page 390, certificate of the chartered accountant as well as the end user. Sir, please reply, please make an argument on the point, whatever, whether we accept or not. What do you say on that? Then we'll go to another point. Other point. Settle what she has said is there's a difference. In those cases, the petitioner or they have collected the cess from the end user. And here is a case they have not collected. What do you say on that? That is what I am asking. Since the respondent herein has passed on to the said burden to the end user and the respondent herein therefore is not entitled to the same refund. Huh? the refund as ordered would not be just since the respondent has passed on to the. Only issue for consideration here is whether the appellants were justified in levying this case on mustard oil by construing the same as agriculture's produce and in the consequence whether they are justified in doing so, despite the fact that mustard oil is not included in the said into the act. Your case is in place of this mustard oil, it is coconut oil. And it's not included in the saddle. Same thing, mustard is not there. No, that is not the issue now. He has all fairly submitted. We'll not go into detail of this. Right? So far as merit is concerned, it could not have been. The issue is only the refund. You just let us read. In the instant, though, at the first it was ordered that payment of the levy would be subject to decision of the appeal, it was directed that cess collected on account of mustard oil should be carefully accounted for. The contention of the litigants appeals would be more appealing to us inasmuch as the respondent had passed on the amount of cess paid by them to the end user as a cost of the product. Therefore, the decision in the case of so-and-so relied on the learned concept by appellants would be more appropriate in the instant again. It will be a case of unjust enrichment if the case amount which was collected from the end user directed to same. The fund has been indicated with a specific reference to the manner in which it will be refunded to end user. Therefore, the appellants as no details of refund has been indicated with the specific reference. Therefore, the consideration says, that you have to justify. That is the same thing. They collect the cess from the end user, right? And it has been refunded to them. In that case, only this will apply. What she has done is she has placed on record the certification by the chartered accountant as well as the end user. This is end user, other. Page 390, 90. If there's a difference, if they are not paying it to the or collect, they have not collected, and if collected, they have not been. I mean, if they are not collected from the end user, they are claimed that they have not collected from the end user, therefore they paid it from their pocket, so we will have to refund. It's 36 lakhs or 3 crore. Huh? I agree. There can be a difference. This can be distinguished. It is only on the basis that the petitioner in those cases, in Tinsukia, they have collected from the end user and there is no detail of refund to them. Here, what she has submitted, she has projected is that they have not collected. Petitioner has not collected at all from the end user. But why you have not collected? It will be passed on because you are selling it to the end user.
Then it will show the government will catch me.
Why this Tinsukia, what is called?
government, so that is not an MRP basis. My products are all MRP basis. I cannot even if I try to collect. I
Hmm.
cannot collect.
Okay.
Because my product will be 10 rupees everywhere, all over India.
So Merito, we don't have to go in detail. We'll go by the judgment in this thing. But yes, anything else? If there's a difference, you have to. What another day? Huh? Sir, that has been settled. Oh, in Tinsukia matter, it's a mustard oil, not the mustard. Here is a in the cereal, it's a coconut, not the coconut oil. That has been settled by single bench and affirmed by the division bench. Where is the settle? Did you have you annexed that thing provision?
In fact,
Which page?
the IDCB 17.
So the act is page 45. Hmm. Yes. So yours is coconut oil. Coconut oil. Yes. You take instruction at 2. We'll take it up at 2. We cannot afford another day. We have come back after so many months. Huh? Huh? No, Friday is not possible. Friday there will be cases. It's not like sir outlying benches. We have limited cases, but every day we're having a on board we have 50, 60, 70 matters every day. So very difficult. No, you just go through the judgment of Tinsukia. In this case, you make your fair submission. Huh? So you go through this, whether according to whether there is a difference, there can be a distinction. Can we distinguish? You go through this. That we are not concerned. Once you have collected, since you have found that the case was the cess was not collected as per the law, right? It was wrongly or illegally collected. Therefore, you have to refund it. Their money. Huh? Let us see financial condition. But if it's their if it's their money, the financial condition should not be should not come in their way. Or for that we'll have to say that it was rightly collected. You have wrongly collected, and then you are having a financial problem. What's
we are not. But the passing window. Because of the reason of religion.
This is different case. Metro was, this was collection of the cess after introduction of the GST.
There not be only. There. Nobody was. They were going state, but after 2020, this was no longer there.
So your cess also collected under section 21. But in the, check that.
That is what.
Whether the respondent board or market company established under section 7 of the Act of 1970 would have the power to levy cess. Then they can collect.
And if tax has been now merged after the Bank of Guilty, they have got merged.
Was observation that the claim for refund can only be
Other side, they will find it, but merged in guilty. It didn't fail. The GST department had given a undertaking. I found the computer.
and unless if it is alleged and proved that the person from whom the tax was illegally collected had not passed on the parliament. Here also it says, in the instead, there are no abatements made in the rate periods that the goods which have been brought for resale, the burden of sales were not passed on to the customers of the petitioners. Para 28. That's all. Why? There's nothing. Involved trade statement by Laniston Consumer inclined to relate the British approach come to restaurant for claiming refund sales collected in month of and any other period along separate months. What is the provision? The London Council Budget has further submitted in this case, the petitioner has also prayed for refund of rupees so and so which was charged and collected as per notory as the agreement says on purchase of mustard oil imported from Watsudi state during the month of October. On such prayer being made by London Rule 25(1) of Assam Agriculture's produce market general launches and has submitted in respect of claim of British for report. It will be open to the British approach. Subject matter involved is to abide by the said judgment order passed by division municipality.
And whether they are intended for or not.
So involved in the is clearly covered by the judgment orders. What is the pleading here in this case? No, provision is okay. Refund of certain amount when any sum has been deposited or grant of license which has in fact not been issued. A person has wrongly applied and paid for and been granted 2 or more licenses. What is this? 25(1)(e). Any money has been paid by mistake. The chairman board of the committee, as the case may be, still on written application being made within 6 months of such deposit. And such inquiry as he or it may consider necessary order the refund of the appropriate amount which shall be appropriate person concerned after preparing a refund out of marketing. No. Any money has been paid by mistake. It's not a mistake. You have collected, so without authority you have collected. Uh, 21. Where is 21? This is refund of certain amount. Huh? Page 32. No, it's okay. Where is the appeal? I mean, what's the appropriate remedy? I mean, forum to ask for where, under which provision? That's why I'm reading. Any money has been paid, refund of certain amounts, section 449. What is section 449? May either general especially what a president of the qualification voters. Huh? Where it is? Where you are reading? The application for refund shall contain such particulars as are necessary to enable the amount for which is claimed to be traced. But under which? This is, you are relying on 25E. Any money has been paid by mistake. The chairman of those, as the case may be, shall on return application being made within 6 months. It's not a case of mistake. Rule. Every appeal shall prepare under section of section 8, any other section 8 member. No, first the refund claim of refund has to be money paid by mistake. It's not a case of paid by mistake. In view of the judgment of this single bench as well as division bench, you could not have collected. It was illegally collected, right? No refund. We'll think about it. Or can we relegate it to you to approach the civil court? In any case, not under the rule. In any case, there cannot be a application for refund under the rule. These are the money if it is paid by mistake. It's not a case of paying mistake. You have illegally collected. No, according, but court has held that you could not have collected. That means what? According to you, you have collected, you are entitled to, you have the authority to collect under section 21. Therefore, you have collected. But the court has held that you could not have collected it. Yes, it's not a mistake. They have not paid it mistake. They have paid and then approached this court, which already been determined in the case of mustard. How can you, I mean, just once you, if you agree that the judgment is, this matter is covered by the early judgment of the division bench, single bench as well as division bench on merit, but the question of once it is held to be that you don't have an authority to collect the cess, you have to refund it. Huh? Because there was a case where the petitioner or the appellant, petitioner, has collected from the end user and it was not refunded back to the end user. There's a difference. Here they said they have not collected from the end user, they have paid from their own pocket. You have been given an opportunity. She has not produced just today. It has been filed in the by way of affidavit. It has been brought on record by an affidavit. No, this not. It has been brought on record, sir, when you have not rebutted it. You have not said anything on it. Have you said anything on it? Heard Mr. MS and Hawali. That's all. What for? We'll record your submission. That's all. You are just saying that although his certificate has been issued by the chartered accountant and the end user, but it doesn't contain any memo number or letter number. That is your submission. All right. Then counsel for the petitioner. Petitioners. Hmm. No, we'll not say that. We'll in case if I find that it is be refunded, verification and everything will be done. And not simply blindly refund it. Will not say. Yes. So you'll have to verify. I know that you'll file an appeal. But then we're helpless. So merit we're not going much, defined to because division bench and coordinate bench has already been, and the division bench has already upheld 288, WA 288. I'll submit that you have fairly submitted, it is a covered case, right? That will go and then refund will say something, whatever is there. On refund, we'll decide. I'll decide. All right. For the petitioners. And also heard Mr. NJ Gogoi, Learned Standing Council for Assam. What is this? Assam State Agriculture Marketing Board. Respondent number? All the respondents. All the respondents. Please stop. I'll pass the order. Dispose of. But what about the money which has been paid by them? Where is that? 249. Page 249. Affidavit. In a similar matter, related matter. No, claim is before the repeal. Claim is the period for the, the before repeal. Saying what? It's okay, we're not concerned. See, this has been settled by the division bench, right? Now only issue is to be whether in the facts of this case, whether the petitioner is entitled for refund. of the cess collected. That I'll consider. Dispose it of. All right.
ৰাখিলেও নেকি বাই চান্স আৰু
আৰু আছে কিবা? এই ভাই তিনচুকীয়াটো না? তিনচুকীয়া আপনার ফাইল আছে এতিয়া আপনি কি করব করো এতিয়া বই কেন করো নাই 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 পাছত পড়ক আপনি আছে আপনি তো 2 ঘন্টা লাগাই না আপনার কাছে কোড ফ্রি আছে
এইসব নয়ন অভ্যাস ये ऐसा पास से मिनिमम प्राइस है
স্যার এই রে সবজি সব
ए मामा के जो मामा जीवन ला
আগে তো কি লাগে কে কে হলো কে হলো
कौन है
কে আছে এই হইলো
वो नाले को
ও পিকনো নম্বরও
कौन कौन
পিকনো নাই পিকনো নম্বর আরে আপনি আলমান ভাই
ये भी बोलते हैं ना बोलते हैं कब तक मैं मुझे बताते हैं ए ये ना बाहर
চলেছি তো এন হাবিলিয়া তো এজনৰ নামাই আহিব চবৰ নাম নাহে না নহয় নহয় চাৰে এজনৰে দিব যোনে ক্লিক কৰিছে এই post
নমস্কার আপনারা নিজেদের স্টাফ দেন আপনারা নিজেদের স্টাফ দেন এটা স্টাফ দেন বলে বলে গাইছে হ্যাঁ
unwanted file দুইটা থাকে আর পেলে না নাকি আমি তো বলছি okay.
Yeah. क्या हाँ बजा दीजिए
तो इनको बैठा के चले जाइए ना।
वो खुला है जैसे पता नहीं
हाँ बोल दीजिएगा।
ये बंद
हाँ? कहाँ आपका? वो बस बच्चा का।
वो शायद चला गया
नहीं ऐसा क्यों नहीं
वो तो
अप्रोच लगी थोड़ा नरम करके तो अभी बात भी समझता हूँ। कुछ करके प्यार से तो कह रहे हैं
हमने यहाँ पर देखा हाँ Yeah. Yeah, that's gonna be. Yeah. Sure.
রিপোর্ট হারিয়ে গেল তারপর সময় লাগলো আপনি দেখি আপনার তাই হবো আমি দেখব Sitting Koreas ra. Sitting Koreas 039. Base ID. Base ID. No, no, no. Chicken that here is yeah. So I'm going to go on to say, I'm going to go there. I'm going to line.
May kindly see is a matter which pertains to installation of lifts. There's a tender which was for installation of lifts. This court Muraz had passed an order. But I'll just briefly Muraz give short facts Muraz. But there were only challenges to the extent that they have mentioned certain brand names in the lift tender, thereby making it restrictive Muraz.
Yes,
This court relying upon a Supreme Court judgment,
Omega elevators.
Omega Elevators Muraz.
Yes.
No, the court had said that you cannot mention brands like this without following any process. And Manoj, the court had asked them to Manoj, file a preliminary affidavit. Manoj, now that affidavit is on record, Manoj, they've served as a copy. Manoj, in fact, it does not deal with the parameters which this court wanted them to deal with. Manoj. If your lordship may see the order first, Manoj. Paragraph 7, may I read, Manoj, for a moment?
Yes.
Of the order, Manoj.
Yes, yes.
From a perusal of the above judgment, it therefore prima facie appears that Supreme Court had frowned upon the Gwalior Municipal Corporation for excluding the Indian brands and only including the international brands. The Supreme Court had also observed that Gwalior Municipal Corporation ought to have acted in more transparent manner. In that view of the matter, this court directs the respondent to appraise this court on the next determined date as to whether there has been scientifically supported conclusions arrived at by a competent authority by following on objective analysis by an expert team that the brands mentioned in the bid document can only be considered, leaving aside brands like the petitioner or other brands. Mr. Asurkar, the learned counsel of the petitioner, however, submitted, then the date was extended, Mulad. Now, Mulad, your lordship may kindly see their affidavit, Mulad, which they have tendered. Your lordship has the affidavit, Mulad, which starts from page number 289.
Yes.
Your lordship is having this affidavit, Mulad.
Yes, preliminary affidavit.
Yes. Your lordship may go to page 289. I wouldn't want to read the entire affidavit because the crux, Mulad, is at page 289, which is the minutes, Mulad, which they have produced, Mulad.
289.
289.
Yes.
And there, Mulad, your lordship would see they have taken technical specifications and then which brands were considered. And then I am at item 4, Mulad, discussion on Omega. Lordship has it?
Yes.
It says Omega was considered due to its competitive quotation and compliance with the technical specifications. So here, Mulad, they are agreeing that I fall within their technical specifications. However, concerns are raised regarding Omega's relative limited network and operational experience in handling institutional projects of this scale. Mulad, this I have objection to, Mulad. But this is a 41-year-old company having turnover of more than 300 crores. not only that, Manoj, we have installed lift in Rashtrapati Bhavan. We have installed lift in the tallest building in India, which is in Bombay, Manoj. We have executed a project which is of 98 crores in Gujarat Metro. Recently, Milords, a project of 9.85 crores was granted to us by the railway authorities in Assam. Milords, this is a statement which is made very loosely. Thereafter, your Lordship may kindly turn to page 290, Milords. Decision taken, Milords.
This is review process is after the order of this court.
No, this minutes, Milords, surprisingly, I don't want to go into the fact that this was before or after.
Hmm.
It is dated 21/11/2024. But even otherwise, I can come out of it, Milords. Because there are more than 300 orders, work orders for more than 5 crore rupees. This is a 77 lakh rupees tender.
Hmm.
The reason to approach this honorable court is to, Milords, because this is against the principles even issued by the Prime Minister's office, Milords. Your Lordship would kindly see, if your Lordship may kindly go to the petition, Milords, for a moment, Milords. And
What is
petition, Milords.
on it?
Your Lordship may go to page 266 of my petition, Milords.
Explicit based on service concern. And service. Sir, it's not only about you. So many companies that it has been rejected.
So we are before your Lordship, Milords. And your Lordship may kindly see, your Lordship may, I am not
Only
saying-
Otis, Schindler and Con. It has been considered. Jensen was excluded. ThyssenKrupp and Omega, Mitsubishi, Hitachi.
but they have been included in the list again. Your
Hmm.
Lordship may kindly see the list. List, Milords, is at page 29. Your Lordship may kindly see the list which is at page 29.
That's why I'm asking, when is this was of 21/11.
21/11/24, Milords. We are in almost in August, now September will start, Milords.
Hmm.
Your Lordship may go to page 29, Milords, of the petition first, Milords. 29 bottom, Milords. It says qualifying criteria for participation in the tender.
Hmm.
This is frowned upon, Milords. Only following brands eligible to participate: Kone, Otis, Schindler, Mitsubishi. Then next page 30, Hitachi and Fujitech, which have been excluded from this by their minutes, Milords. This is self-contradictory.
Hmm.
But not only that, now your Lordship may kindly go to page 266, Milords.
These are foreign brands or
All
India?
foreign brands, Milords. That's why, Milords, for a moment, your Lordship may kindly go to page 266.
Hmm.
Page 266 of the petition, Milords. Look, this is a communication dated 3rd of January 2019 issued by the Prime Minister's office, which says complaints have been received alleging that government entities are indicating foreign make brands and or restrictive conditions in their tenders, thereby excluding local manufacturers from the bidding process. It may be noted that such stipulation of foreign brands or restrictive conditions line mandatory requirement of certification by foreign bodies in tenders is not only violative of public policy issued by DIPP, but also in violation of general financial rules. In this regard, it is necessary to follow following general guidelines. Indicating foreign make brands in tender and thereby excluding local manufacturers and service providers from participation is in violation of public procurement as per rule so and so. Procuring agency shall not indicate a requirement for particular trademark, trade name, or a brand.
Hmm.
The technical specification shall, to the extent practicable, be based on national technical regulations or recognized national standards. Ministry department should also ensure that their procurement entities do not incorporate any such restrictive or discriminatory eligibility criteria regarding turnover, specifications, testing, other standards in tender documents that exclude local manufacturers and service providers. Plus, I am not saying that you grant me any special treatment. I am ready to compete with all these manufacturers, Milords, because I have put in my bread and butter for the last 41 years, Milords, only in this business.
Hmm.
But here, Milords, this is reverse discrimination, Milords, wherein they are favoring foreign brands only on the ground of reputation, Milords. And Milords, I would take your lordship to other 15 orders of other different high courts where they have been frowned upon, these entities, Mullahs, by simply indicating brand names. I am saying you lay down a technical criteria. If I don't match that technical criteria, I am out. But you create a super technical criteria which is not allowed, Mullahs. And Mullahs, this is IIT Guwahati, Mullahs. We have installed for IIT Kharagpur, we have installed for IIT, we have installed lifts at IIT Chennai. The Indian Institute of Technology also we have installed lifts, Mullahs.
Hmm.
And you'll also make also kindly see page 272, Mullahs.
Yes, 272.
272, Mullahs. Now, this is Mullahs, public procurement, preference to make in India, revision regarding this is dated 29th of May 2019. Will Lordship has it?
Hmm.
Now, your Lordship may kindly go to Mullahs.
Make in India.
Yes, Mullahs, your Lordship may kindly go to page 275 of this document, which is paragraph 10, Mullahs. Mullahs, paragraph 10 says specifications in tenders and other procurement solicitations.
Where it is?
Page 275, Mullahs.
Hmm. Paragraph 10. Yes.
I am at paragraph 10, Mullahs.
Hmm.
Specifications in tenders and other procurement solicitations.
Hmm.
Every procuring entity shall ensure that the eligibility conditions in respect of previous experience fixed in any tender or solicitation does not require proof of supply in other countries or proof of exports. Procuring entities shall endeavor to see that eligibility conditions, including on matters like turnover, production capability, and financial strength, do not result in unreasonable exclusion of local suppliers who would otherwise be eligible beyond what is essential for ensuring quality or creditworthiness of the supplier. Imagine all these criteria, Mullahs, this tender, Mullahs, deserves to be quashed to the extent that they cannot, Mullahs, insert brand names, Mullahs. Let everyone who is otherwise technically and financially viable participate and compete with these foreign brands, Mullahs. I am not saying that you exclude the foreign brands. You may allow them. If it had been a petition venting, I am saying that your Lordship may kindly issue a mandate as directing them to exclude the foreign brands. It would have been different. But I am saying that you let them participate, but you let us participate as well.
Hmm.
Because we are not asking for any favoritism treatment. We are only asking that you treat us equally because we have earned that for the last 40 years.
That's all.
That is all. Your Lordship may kindly permit us to participate in this tender. The date has been extended to 5th of September, Mullahs.
5th of September.
Mullahs.
Yes.
And Mullahs, the Rashtrapati Bhavan installation is also at page 168.
Hmm.
Your Lordship sees.
Hmm.
168 is a type copy, Mullahs. Here, Mullahs, we have installed a lift at the Rashtrapati Bhavan. Thereafter, your Lordship would see page 167. Sorry. 165, Mullahs, is the tallest building in India, Mullahs, where we have installed the lift, Mullahs.
Where is the NIT?
Please, Mullahs, your Lordship. Page 25, Mullahs. Page 27 is the name of the work. It's new installation of 4 numbers of 8 passenger lifts at Administrative Building, North and South Block and Academic Complex, Core 1 and Core 5 at IIT Guwahati campus.
34 is what?
24,
34.
34, your lordship.
Page 34.
34 is an NIT, well, this is as it was available to us to download models.
Hmm?
Page 34 is also the NIT only models.
Which NSD you are challenging?
29 and 24, you know, they're the same. They are as they are downloaded from the internet model. This is how they have been available to us.
Hmm?
This is how the content is available from the internet. It is downloaded.
This is 7 August 2025. Is the date of download or what?
Your lordship is at page 34 models.
Yes.
At the top, just below the notice inviting tender, your lordship would see dated 24th of June 2025.
Yeah, this is the date of tender.
Yes, sir.
NIT.
Publication of NIT.
Then what about this page 25?
25 models.
25. Page 25.
No, these are the timelines which are prescribed models. Your lordship would see here critical dates at the bottom of page 25. Your lordship would see
Hmm.
publication date 5th of August 25, bid opening date 27th August 25.
Date of notice inviting tender is 24/6 June,
24/6.
which is as 8
Yes, yes.
is 34.
Please, Manoj. Now, Manoj, page 34, Manoj. At the bottom are the brands which are listed, Manoj. And thereafter, your lordship would see
Whatever the average annual turnover,
we are qualifying, Manoj.
3 consecutive years.
Yes, yes, Manoj. It says average turnover should be 36.62 lakhs, Manoj. We are a 300 crore company, Manoj. Around 2,500 employees, Manoj, and 19. We have 19 regional offices. Even in Guwahati, Manoj, we are since last 25 years.
Yes. Yes. Yes.
What you frequently what you use that is what our students should physically savings. That's why it become urgent. Now we are also that the question is presented by Lord Honorable Court and as well as the Supreme Court also. Whether we have taking the decision experience some of the companies whimsically or based on some analysis, positive analysis. That is the question. The physical companies serving election of the president followed by India, some part of you, that is not the concept. Concern is better we have taken this issue to exclude the physical company and some other company. Based on soft analysis, positive analysis, based on logical analysis, scientific. Here, I consider 3 aspects which they consider. Firstly, they are in the last phase. Mentioned
Page 290.
our education was last phase, what's the kind of last phase? The brands were selected on the top. Then I said, that's last thing.
Mm.
The brands were selected on 3 particular parameters. One is global performance. That is what it was. The second is
Where is page
at the last page 290.
219?
And next one was the last page.
Hmm.
Our
Hmm.
the brands were selected. You have to consider 3 factors. Firstly, global performance. Secondly, service reliability. And thirdly, the most important one, existing installations at IIT Guwahati. Because we supply particular things to foreign countries also, President Obama, whatever. The question is existing installations at IIT Guwahati, what is their position? That will depend, services that we require. These 3 factors were examined
And what should we kindly see? They have done everything. It's distinct from the case Supreme Court decided, which is their balance.
Hmm.
What we kindly turn to page 283 of our CW. There are 6 versions. The Computer Control Institute thereafter decided to issue a fixed benefit on the forced procurement. So this, the texture is comprising experts from the Computer Institute was considered and formally entrusted in the mandate, finalize the technical specifications and to recover a panel of manufacturers based on their districts parameters again, proven performance, service reliability, and the satisfactory operational history of existing installation within IIT Guwahati campus. There are network services available at IIT Guwahati campus or North Guwahati campus. They will be supplying lifts to Bombay or the President Bhavan and Prime Minister Bhavan. The question is, what is their network connection reliability at this area? So you now can see very further logic.
If you don't
Hmm.
authorize, how will I? Even if
The
you
state technical committee is deliberated at length
can't use.
on the maintenance solution of the agencies of the elevators, manufacturers scheme to the extra government. The committee is expert judgment. And I will specifically find this concerning the express company which are reported here below. But reference of this number 4. Number 1, this is quoted. Discussion on Omega. Omega was considered in its competitive profession and compliance with the technical specification. However, on consumption rates regarding Omega's relatively limited service network. This is the most important relative service network portion. And operational experience in handling institutional projects of this scale. This is the opinion of the experts from they have not yet have arbitrary explanation. They have considered this as the experts to say. They need a logical analysis and counterfeiting this development. But doing single that because foreign company, you cannot explain. I mean, there cannot be any presumption that it's a bad government. Which should be precisionally taken. Now, on the ground here, what is its capacity? We have doubt that their limited network connections to IIT Guwahati. It's related to IIT Guwahati. It's a great company, Omega. We are proud of that. Supplying leads to Bangladesh, Pakistan, and other countries also.
No, not Bangladesh and Pakistan.
Whatever. But actually, we are related to network services available with the IIT Guwahati. We are concerned with that only. Because of this, now entire question to go raised from our report also. In the initial order say, whether this exclusion or inclusion is based on some logical analysis based on scientific. Here we are concerned with big chief factors that I've stated. The performance, you must get that here, you want to consider that performance are proven. You may very comfortable saying that what is the service solution? Service reliability and existing installation and IIT Guwahati. These are the weight factors that should be required. They have a very good network currents, installation and pricing of that, here. Who are notice is not capable. We shall be immediate if you not getting service. So that is the test only to better we have done it ultimately. All on the basis of some tests. Therefore, this exclusion.
But sir, you have rejected this excluded Mitsubishi, Hitachi and Fujitec. But in your NIT, you have included them.
So that is why high out was directed to a notebook. The question is whether
This is the higher authority for some consideration.
According to you, this Omega
Lordship.
has installed the lift there in IIT.
No, they're not installed.
Other-
How do,
They are,
Other IITs we have installed.
they may be, the question is network connection using the LAN, where it is to be installed. What is the
no,
network?
how do you say that about their relatively service and all the thing? When you have not tested them,
No, because we cannot test them and see that if you're not satisfied, then we
then
cannot
where's the
have it.
question of your being the proven performance, service reliability and existing installation at IIT Guwahati?
These three we are not aware of, that's all. But
What about
existing-
Omega?
Existing installation in IIT Guwahati. They may
Is by the Omega?
integrated Omega, that's why I excluded Omega.
Is it by the Omega? Who has installed in IIT Guwahati?
No, this is by some other companies earlier. These are
Then how
they-
you can exclude them?
They are 20 years old companies.
You say it's a proven performance, service reliability, and existing installation at
These are
IIT
three factors we
Guwahati.
examine. Our technical committee examine. They have taken up all the leading lift manufacturers,
Ah.
including Omega and including some other companies. In case some of them they have excluded. including
So you have
Omega.
excluded ThyssenKrupp and the Omega were excluded based on service conditions, concerns and prioritization of brands with established network and proven performance.
Yes, Lordship.
Why, how can you say that it's a proven performance?
Technical committee's Lordship opinion.
This is
Their
something.
specialists, their technical committee, this is the opinion.
And you have excluded three, your technical committee excluded these three, Hitachi, Mitsubishi and Fujitec, but you have included in the
They have
NIT.
not, it's limited to the expert committee's opinion,
Hmm.
based on which they are excluded.
Ah.
Now, for what consideration, higher authority ultimately included three other companies
We're
that we are
concerned,
not concerned with now at the moment.
no, we're concerned about all the higher, including your higher authorities. When you have excluded based on this technical decision committee, excluding three and another 4, 5, 6 companies you have excluded. Johnson, ThyssenKrupp, Omega, Mitsubishi, 6 you have excluded.
Johnson excluded, Lordship.
Now you have excluded out of this three, you have included 3. Why?
Lordship, you can see that Johnson, why we excluded, mention it at, at page number 289, where petitioner company was also considered.
It's
Brands-
okay, you have excluded. What I'm saying, Johnson and the ThyssenKrupp and Omega, they have been still excluded as per the NIT.
Yeah, Lordship.
But you have included these 3 other Mitsubishi, Hitachi and Fujitec.
They were also excluded by the committee.
Hmm.
Technical committee examined it, but some other considerations that the higher authority directed. that
What
this-
is the other consideration? That is the
That is not-
kind of restrictive.
Committee
You cannot
limited to
have
the
that kind of
technical
thing.
committee's observations.
See, they are not asking for the tender. They want to participate in the tender. And this your reason for exclusion is also not reasonable.
Because you want a competition among the companies whom we are satisfied that they'll be able to give us services.
Sir, that's why I'm saying you have excluded 6 companies,
Lordship,
including the petitioner.
Lordship.
But in your NIT, you have again included these other 3.
The company that is, they want probably a healthy competition. I do not know what for reason.
So what's the problem in allowing them to also?
Because these factors are not there, not satisfactory.
No, one could understand if you're relying on this technical committee's the decision.
That is so.
You have only, the committee has only selected finalized three companies, 3 brands.
Sure.
Otis, Schindler and Kone.
Lordship.
Now by your NIT, you have included 3 more companies, I mean brands which has been excluded by the technical committee.
That we shall reply that if that question comes to us, they will certainly reply, file affidavit, why you have included that. That was by the data. After all, this report was submitted.
No, since you are relying on this, you will have to show that this proven performance service reliability, how from where you are getting it? And an existing installation at IIT Guwahati.
Lordship.
That's why I'm asking whether the Omega has installed in IIT.
No, they have not
They,
yet established.
how you have
Probably
tested?
that is,
How you have tested them?
And the expert committee, they know, they're the technical.
How?
expert.
That is the.
Then we'll find an affidavit and take the opinion of the expert committee, Lordship.
And that too, nowadays, if the government of India and the country is on the making in India,
So these are all good here, but here in this particular.
you have to encourage making in India.
Nothing to do with the Indian company or foreign companies here. Question is, we have.
You have only shortlisted and penalized the foreign companies. I'm not saying that you cannot.
No, they
Go
happen
for
to be
it.
foreign companies. Lordship,
Why
that-
you have to deprive the making in India?
Lordship, that's not.
That's the
another question
policy.
is-
That's the policy of the country now.
That we shall satisfy Lordship by filing necessary affidavit. But now, at this stage, question is, the exclusion and inclusion companies is based on,
Will this when you have extended
they have extended up to Lordship.
5th of September.
5th of September,
Lordship,
we'll take it up on first. Actually,
Lordship,
on final disposal.
Lordship,
Before that, you file whatever affidavit you want to file. You file it.
Lordship, on this question.
Would your lordship have it on 4th Manoj?
Huh?
Would your lordship have it on 4th Manoj? I come from Gujarat Manoj.
Court is
First,
last date is on 5th.
5th Manoj.
So
Court will be too closer.
Manoj, I will also bring all those work orders and completion.
no, work order is not required. It's in fact the issue is very simple.
Please.
Yes.
Why not convinced because the justification given by them? That's why. Otherwise, the matter could have been disposed of today also.
Lordship, we take it up on 2nd of September, Lordship.
September. You allow him in the meantime to participate. Because it's not, well, you are not completely, you didn't go completely by the decision of the technical expert committee.
That is the way.
Expert committee has excluded six companies, but by your NIT, those out of 6, you have included 3.
That is Lordship, that now presently the basic issue on this matter, immediate issue is that whether we have excluded or included any companies on the basis of any technical committees.
That's then why you are relying on this.
Lordship.
And why not satisfied that
Shall
the
satisfy Lordship of-
basis of your selection? These three the criteria: proven performance, service reliability, and existing installation.
Lordship, that is,
What is this? This is contrary to your submission.
And there's one more document, please, your lordship may kindly bear with me, page 271 for a moment, your lordship.
What is that?
So that is a notification issued by the Central Public Works Department, wherein all these foreign brands have been discontinued. Your lordship may kindly have a look at it. Page
By whom?
these are-
By the CPWD, Manoj.
It's okay. We'll
these are
not.
not necessary issue,
These,
Lordship.
so these 3 brands, Manoj, probably Otis, Kone.
No. In fact, we cannot tell them to include and not to exclude.
Exactly, please, Your Lordship.
What is if it has to be competitive bidding, all the eligible brands should be allowed to participate. That's all.
Lordship. So,
Participation doesn't mean that
finally hard, but
they'll
it
be
is-
given. You will analyze their these whatever this performance, whatever service
there
reliability.
will be a expert committee that
When-
will analyze
Yes.
all technical subjects. Lordship.
How can you have this kind of predetermined kind of these omega and then all other these brands will not be accepted?
Some
It
brands
cannot
are
be-
allowed,
cannot
others
be
not
extended.
also.
Is this the system of finalizing the tender?
Before Lordship, the tenders are not finalized. This is NITs given to.
That's what I'm
some-
saying before.
Before Lordship. Tenders are finalized on that period.
The NIT is approved for final submission. Yes.
Yes, they want a competition among the only tested companies so that there will be no default. We cannot take any risk. So before we issue the NIT to the parties which are already tested in the market or in that level,
How you have tested Omega, the petitioner? That's what I'm asking.
so the expert committees probably they look up all aspects, then come to the.
And
conclusion.
the same thing, I'm just repeating. You have excluded another 6 out of 6. You have included another 3. What does it mean?
That was for some other consideration by the government.
What other considers that you cannot?
That at this stage also I cannot, at this stage, that has not been the question now. We'll answer that question also.
You file a detailed affidavit or not before 2nd will you exchange the affidavits? parties may extend as well, then we'll finally dispose it of.
Lordship, as a lordship business.
But better to include them,
Lord-
all the companies.
But other companies are not before lordships now. They have, this company, of course, let's see, we file.
And-
The brands.
And things,
We file a significant lordship's queries, we shall try to satisfy.
okay, heard, mister. We'll fix it on second.
I was
for final
requesting
disposal.
fourth, Mulaz. I was
Huh?
requesting for
Okay,
fourth.
let it be on court.
Fourth, it will be difficult because like that, you cannot afford to, I mean, wait for some more days.
If your lordship, Mulaz, I am hopeful that your lordship probably finds something in my favor. They will extend it.
No,
for
no, we
another
cannot say
week, Mulaz.
today. Only where I'm just expressing
No, no,
that we're not convinced the just preliminary affidavit which they have
Fourth,
projected.
third is a miscellaneous day in Supreme Court, Mulaz. I will have to go there and come here, Mulaz. That is why I'm saying if your lordship may have it on fourth, I'll be here.
See, fourth, for me, it's not a problem, but the tender is, last date is on fifth.
Fifth.
Can you submit on fifth in
We
case
sub-
if you are allowed?
We will submit it, Mulaz.
Is it-
Our
Don't-
bids will be ready.
And
Mulaz.
ensure that you don't ask for further extension.
These are all online
Will
services,
not
lordship,
extend.
within the five minutes they can complete it.
If a favorable order is given, your lordship would extend it, Mulaz, and allow us to participate. Or Mulaz, they would probably withdraw this NIT and issue a NIT where they don't specify any brands, Mulaz. That's what I'm saying. If your lordship may,
I think, sir, you shouldn't mention the companies.
that is all.
You should give some,
Don't
I
try
mean,
to
give,
satisfy
there'll be a competitive bidding. If you want to get the best of it,
That we want that.
what's the
competition for
problem?
Lordship.
What's
We
the
want
problem in
that
giving the
competition also
competitive
among
bidding?
the very competent parties. We are, with whom we are satisfied that they will be able to, we have some confidence that they will be able to.
You just cannot, it's like you are making a remarks against a brand
Not remarks, but.
which you have not tested, whereas the basis of your basis of your finalization by the expert committee is based on some performance, service reliability. When you have not tested them, how can you just give a remarks, a negative remarks against the brands?
Not regretting, but these factors we are not satisfied.
And the policy of the country today is to encourage the Make in India.
And that is, suppose that is, we are not, not driven up to that stage. Lordship. We are saying. we
No,
want
at the same time, we're not saying that you should only go for the Make in India, but they should not be discouraged.
The question is our service guarantee with regard to mostly
That's why I mean, how can you give a,
physically disabled students.
how can you decide now, predetermine,
That's why you,
only unless you have tested them.
no, then will be.
Better,
also-
matter would have been different if you have tested them.
but
They
we
have
to
installed
test
in
only
earlier
companies.
and
which we
there's a
have not
service-
Satisfied, you're not confident that they'll. be
Service
better.
problem, performance and all those things. How you have tested them?
So that is difficult because we have test and yet then if it's companies who are in network of this, then it's gone forever. We have to take the headache of again repurchasing another lead.
The technical and other, while you are evaluating a bid, and all these things should be there, performance, everything will be there. You put some condition which is equal to all of them. Why you have to exclude some, the bidders
Then at all.
who is otherwise eligible?
Fujitech and Hitachi, Mulaz, are actually because they don't have a service center here, and then they are including them. This is Mulaz, self-contradictory because they don't have a service center.
It's okay.
And, Mulaz, your lordship,
Heard,
Mulaz,
mister, fix it on fourth,
for- Mulaz,
like,
I will provisionally
at
participate in the meantime.
at a cost and risk. No, we'll not say today. That's why I said, we'll take it up on second. Today, until the time we decide the matter, we will not be allowed to, it will be difficult you to allow to participate.
Look, they may not open our fifth.
No,
Mulaz,
no.
Your lordship may kindly
That
bear
is-
with me.
this
I will
issue is-
provisionally participate.
No.
Your lordship may decide it on fourth.
No such
Subject to
thing.
the result of the petition, it can be kept. Mulaz.
No, that will be,
That will be,
this issue be settled,
It
then
will- it will-
it pass necessary order.
I will not claim any equity, Mulaz. Fourth, your lordship may decide it. I will provisionally participate.
No,
Just to
no,
Mulaz.
let us decide on second, that's what I'm saying.
Lordship will decide it and will follow the lordship in that case.
Let us decide on second.
Please.
What do you say? Because the last day you never know.
Distance is the only inconvenience which I will overcome.
This,
No, you decide. It's for you only. For the parties only. I'm saying
Please, Manoj.
this way that we will decide it. Will not
Decide this
keep
issue,
it
then
pending.
the question of
Please. Second. Very good.
The persons with disability, they're facing problems.
that's the best decision. Then taken about-
Current lifts are running, Manoj, right now. These are not new lifts. These old lifts have to be taken out and then new lifts have to be installed. Those lifts are running, Manoj.
No, it's okay. Notice was issued. No,
No. Yes, yes.
notice was issued. Mr. Puskar,
Asurkar.
B. Hazurkar, learned counsel for the petitioner. And also had Mr.
RP Kapoor ki first.
R.P. Kafidi, learned senior counsel assisted by ABD, learned counsel for the respondents, NIT, IIT. Respondents. Huh? This court, while issuing notice on 22/08/2025, directed the respondents to apprise this court as to whether there has been any scientifically supported conclusions arrived at by competent authority by following an objective analysis by an expert team that the brands mentioned in the bid document can only be considered, leaving aside brands like petitioner or other brands. Stuff. Today, respondents have filed a preliminary affidavit. List of perusal of the affidavit indicates that the branch of the petitioner was evaluated on its own merits against objective benchmarks, i.e. proven performance, service reliability, and existing installation. Thereafter, was excluded for specific documented concerns regarding its limited service network and operational experience in handling institutional projects of the kind of the scale of the present project. Next para. It appears that the technical minus, what is this? Is it a technical committee or what? NIT,
Technical committee also.
the technical committee
Good.
considered as many as 9 brands, including the petitioner. Mr. Deva, please tell. It finalizes, it had finalized grants for Otis, Schindler, and Kone, and excluded ThyssenKrupp, ThyssenKrupp, Mitsubishi, Hitachi, and Fujitec brands. No, Hitachi and Hitachi, Fujitec, and Omega within the petitioner hearing. However, which is to be, which have to be, not which have, please stop. The committee has submitted. The committee consists of 5 members, but minutes of the meeting dated 21/11/2024 has submitted the decisions finalizing the brands, namely Otis, Sindler, and Kone, by excluding another other 6 brands, including the petitioner. Stuff. However, by an impugn NIT dated 24/06/2025, the only brands to be eligible to participate consist of Kone, Otis, Sindler, Mitsubishi Elevator, Hitachi Lifts, Fujitec Elevator. Perusal of the NIT clearly indicates that the authorities issuing the NIT has not, appears to have not followed the decision of the technical committee, as the technical committee has finalized only 3 brands, namely Kone, Otis, and Sindler, whereas by excluding Mitsubishi, Hitachi, and Fujitec. Stuff. On a wanted query to the effect that when the authorities have relied on the technical the decision of the technical committee, why other 3 brands, namely those last 3 one, Mitsubishi, Hitachi, and Fujitec, which have been excluded by the committee, have been included in the NIT. The Land Senior Council phrased for some time to place the regions, and also place for and for filing of detailed affidavit to the writ petition. List of next period. Considering the matter, which pertains to installation of lift at IIT Guwahati, and the submissions and prayers of the Senior Council for the respondents. Let this matter be listed on 2nd.
We will not be able to respond by 2nd their affidavit. Lordship may, they may serve us a copy on the 1st, their affidavit. We will file our affidavit by 2nd. Your Lordship may have it on 4th. 2nd or 3rd, we will file our affidavit also.
So fixing the date on 4th.
4th.
As you wish,
Yes.
but at your risk and cost. We're fixing it at your risk and cost
No, 2nd
on
was they,
4th. Anyway, what is the last? Listed on 04/09/2025. Mr. The respondents may file their affidavit. The respondents to file their affidavit on or before second of 02/09/2025.
They can file it bit early so that it will give us some.
And
It not be
in
possible.
the meantime, and the thereafter. By furnishing the copy to the land council for the petitioner. And the petitioner, land council, the petitioner may file their reply. Before fourth,
Yes, that is only, your lordship may direct.
or not
them-
before fourth of, not before fourth.
Let 10:30
Endeavor shall be made to dispose of the matter on the next date.
Your lordship may have it on 10:30 in motion list.
Huh?
Would your lordship have it on, subject to your lordship's convenience, the convenience at 10:30 in motion list?
No, we cannot. It's not, it will be listed for admission only. Notice has already been issued.
Deeply obliged.
List, so that we can dispose it off. We'll list it for admission.
I was
Okay.
requesting if it can be listed in motion list, Mullah.
No,
No.
it's better to list in admission. Notice has already been issued. At least they have filed a preliminary of
Your
affidavit.
lordship may allow us to upgrade it on that day, on
So
fourth.
that will be made a prayer.
We'll
that
see,
day.
we'll see. You make a
That day you
prayer
can
on
make a
that day.
prayer, once listed, lordship. Deeply obliged, your lordship.
Fourth is what? It's a hearing day or what?
Hearing day.
Hearing, your
Ah.
lordship.
Or similarly, as this was listed today at 2 PM, Mullah, that is also, so that it can be disposed of, Mullah.
The Honorable Court is
Let it
already
come, we'll
expressed.
see on that day.
Obliged, your lordship.
So the only apprehension is, Mullah, that there are several judgments of several courts which are in our favor. Today, Mullah, we are looking at a situation, Mullah, I would request your lordship may decide it today itself.
No, this
Like,
should
in
be
fact,
given.
in fact, their submissions are, the reasoning given by IIT Guwahati is of, no semblance as to what directions were passed. Plus, I am making a very reasonable request, subject to your lordship's convenience. But it is obviously subject to your lordship.
Sir, we have
always.
already passed the order. That's why I've asked. You said, let us do, I mean, you sought for 4th of September. Thank you.
Obliged.
We'll take it up on 4th,
Please, Your-
as spread by you.
Yes, sir.
We have
Because
agreed to your proposal on
plus
4th,
on second, if your lordship.
on your prayer.
Plus any day, plus I am saying if it can be in the motion list so that it can be heard. Mullah.
No, we have, notice has already been issued, therefore we'll list it for admission so that matter can be disposed of. If it is listed on motion, for motion, we'll not be able to dispose of.
Please, Your-
Sir, what is this?
This is again for the first time in this case, man. Is regarding our forest royalty. I'm a contractor. Now that particular Numoligarh Refinery Limited has told us a tender. And in that tender, I participated. It is in respect of piling and RCC work for ECU revamp project. I participated. There is absolutely no problem. Work order issued, contract agreement signed. But ultimately, when they said that I have to give an undertaking to the effect that 2% they will deduct forest royalty is concerned. On the basis of forest royalty, have given undertaking to hold my FRCC. And in the meantime, my lord, I challenge the order, some bills which they have withheld. Now, in the meantime, what they have filed an affidavit in this case, and I filed a reply. In the affidavit, they specifically have taken a stand that the source which I collected those materials, the forest material I have not disclosed. Now, my lord, my instruction from my client is that there is source which we can disclose. There are some documents. So your lordship will give us 2 weeks time so that we can bring it notice before the court. My source, which I have collected the material, forest soil material.
They've filed an affidavit saying what?
They have filed an affidavit saying that we are bound by to pay forest royalty to them. As there is a statute under 2021 where it said irrespective you have to pay 2% of the forest royalty. Now this is, my lord, whether we have to pay, whether it is not been added to the terms and condition of the contract. There are few judgments of this honorable court where forest royalty, it
Hmm.
has been said that it has to be a part of the contract.
Hmm.
There are judgments passed by division bench. So now you, Lordship, I am seeking a bit accommodation so that we can bring notice to the court that what is the source I have collected these forest materials. Because their whole stand is that in the affidavit that the source I have not disclosed from where I have collected. Now suppose a material is being collected from forest. So there is no question of showing the invoice where it has been collected from the forest. Suppose I buy it from outside. Now, if I buy from outside and you use it, then whether a forest royalty has to be paid or not. That's the question, right?
You have filed a reply.
I file a reply, but those main documents has not been annexed before this court. Give us 2 weeks time, we will bring it notice.
And for the forest, the only question is genuineness of the forest royalty paid. If they can show that, there's nothing remains a lordship. Only that
Ah.
much. That you paid, whether they paid the forest royalty. They said they acquired from a third party. Whether third party has paid that forest royalty, why acquiring the materials of minerals from the forest area? Only that much question is there, lordship. If they can produce that,
No, we'll produce it.
It's a source of payment or source of collection?
Payment. We have
Payment.
to payment.
forest royalty.
Forest royalty has.
No,
to be
no. What do you want to produce it?
paid. I will.
The
produce
source of collection of the
Collection-
forest materials
collection-
or a
collection and
payment
pay-
of royalty?
No, collection.
Your stand is that you are not bound to pay.
No, I am bound to pay if I can't show before the court the forest royalty because I can't pay double taxation.
Uh-huh.
Suppose A is a lessee with where the contract has been given by the government. Now suppose B has collected from him and forest royalty has been paid. Royalty tax and everything has been paid. I being a contractor, I collect from B. The source which I collected from B has to be shown. Here in this case, what I have found, A and B source has been shown, but C, my source has not been shown. That's what they are saying. If I can show the source of collection, then that's the end of the matter.
And Mr. The Das Lenin Senior Counsel assisted by Mr. So for petitioner. Although this, no, Mr. Das Lenin Senior Counsel submits that in view of the stand of the Forest Department,
NRL.
NRL, to the effect that the petitioner could not place any material to show the source of collection of
Yes.
forest materials
Yes.
for which the petitioner could not be is not liable to pay the forest royalty, comma the further the 2 weeks time may be granted so as to place on record the source of collection of materials as the petitioner is not bound to pay the forest royalty as the source of collection is from the third party,
Yes.
third or second party, what do we call
We'll
it?
call a second party.
Second party.
Yes.
Second party.
I'll
Who,
show it.
who had already paid the
Yes.
forest royalty. Mr. Although this court, considering the issue involved in the matter being the deduction of forest royalty, royalty, no, deduction of amount from the running bills of the petitioner as forest royalty, comma, had passed and had made an observation on 16/07/2025 that the method, an attempt may be made to dispose of the writ petition. List of, comma, and in the considering that the petitioner is required to place on record the source of collection of forest materials and as agreed to by the learned counsel for the respondents, let this matter be listed after 2 weeks. In the meantime, the petitioner may brought on record, may bring on record the source of by an affidavit.
Deeply obvious.
List after 2 weeks. Yes, yes,
Two more to confirm, Malad.
yes.
The contender has violated the interim order.
Huh.
Malad, interim order is at page 6, annex 2, Malad.
Page 6. Yes.
That's relevant at page 9, my lord.
Hmm.
In the interim, the respondents in the forest department shall not proceed further with the tender process in terms of a long e-auction notice under NIT. So and so dated 11/6/2021 issued by DFO Dhemaji Division until further order of the court.
Yes.
And kindly produce the next page 10, annex 3.
Hmm.
My lord, on this order was passed on 2/11, my lord, and on 1/12, my lord, he issued the work order, my lord. That is the work order. 1/12/2021. Then, my lord, the writ petitioner, he filed another
Writ petition is allowed. Writ petition ultimately allowed.
Ultimately,
What happened?
my lord, kindly produce, my lord.
No, I understand. Well, disposing of the writ petition only, but till now there is no response to the schedule. We have disposed of
Both the
writ
writ petition.
by the Yes.
Lordship, we have filed our affidavit, the sole contemner.
Hmm.
Yes, sir. Unconditional apology in this, your lordship.
Hmm.
If I may take to the affidavit file, page 44, your lordship.
That has been taken note of by the,
Yes, sir.
before, while issuing notice, direct,
So he
registering this sumoto
Yes,
contempt.
your lordship.
Then,
So there has been misinterpretation. He seeks unconditional apology before this court, your lordship.
hmm.
So therefore he is that he won't be again in future course. Will never violate this court's order.
No,
your
that
lordship.
has already been taken,
Yes, sir, lordship.
taken care of. You have only taken, I mean, this affidavit was filed before, the sumoto contempt
No,
case was
there-
registered.
Another affidavit we have filed, your lordship.
Huh.
In
My lord, another affidavit was filed,
March.
which starts from page continuous page 41.
Yes.
Hmm. Hmm.
Paragraph 5, Your Lordship, if I may read. And at the cost of brevity, it is reiterated that the deponent had never
Paragraph 5 at page 44.
44
Hmm.
engaged in any lawful disobedience of the order of the honorable court. It is further submitted that the alleged contempt pertains to order dated so and so, passed in so and so, wherein the authorities forest one righted to not to proceed to tender process in terms of the auction notices so and so, which was also subject matter of WPC so and so. However, it is humbly submitted that the deponent inadvertently misread, misinterpreted the order dated 2/11/2021, which lacked willful and deliberate intention behind such the alleged disobedience. At this juncture, petitioner reiterates and begs to tender unconditional apology. Deponent had never willfully passed the work order dated 1/12/2021, and soon as he came to know about this honorable court's direction, the operation of said work order was immediately stopped and seized. Paragraph 6 of it. It is most humbly submitted that a concerned letter of intent was already issued in favor of respondent number 5 of the WPC number so and so and WPC so and so on 19/9/2021, even before the order dated 2/11/21 was passed by this honorable court, directing the authorities in the forest department not proceed with the tender process. The said submission also recorded in order dated 2/11/21 passed by this honorable court. Therefore, humbly reiterated that the deponent has never willfully passed the work order dated 1/12/21. As soon as he came to know this honorable court direction, the operation of said work was also immediately stopped and ceased. That therefore, in light of our submission, is humbly submitted the highest regards towards the authority and majesty of this honorable court, that the deponent tenders unconditional apology, and that the deponent had never engaged in any willful disobedience of the court's order of this honorable court. The deponent had served the government in an unblemished service record at the most 2 years of his service left, and has a number of dependents.
So interim order was passed on 02/11/2021 or, and the order, work order was issued
1/12/2020.
1/12. After a month.
After a month.
Why they are saying that the order, the even before LOI issued,
LOI. 19/9/2021.
that was LOI. You have issued the work order even after the order. Interim order on 02/11/2021. And the work order was issued on 01/12/2021. After a month. There are 6 you have clearly made. LOI was issued before the order of this court
Before this
not to
court,
proceed with the
not
tender.
tender.
There is no dispute.
There's no dispute about it. That's what he's.
Then even after 0/11/2021, why you have
Yes,
issued the
that's,
work order?
That's, yes, he apology about that because he misread the order, Your Lordship.
With the question of misreading, not to proceed, how can you do that?
That's, we have asked him not to do so. Thereafter, he stopped the work. The moment we asked him not, why you're doing this, we have stopped it immediately. So he's,
Where is that order?
we asked him, Your Lordship, over verbally to stop the interim order from this court.
Where is that order? Copy of the 0. No. Where you have is asked to stop and seized. Where is the order?
That page 51, Your Lordship.
Order dated 9/3/22.
51. This is after issuance of the notice.
The present copy of the same Ilvani case, subject was the
This is 9/3/2023.
9/3/2022.
22, huh? This order was passed when?
My lord, after issuing the notice in the second writ petition.
Not before, not after issuance of notice
No, my.
in the writ petition.
No, my lord, there are two writ petitions.
Yes.
The first writ petition interim order was passed on 2/11/21.
Hmm.
After that, on 1/2/21, they issued the work order. Against that work order, the writ petitioner again challenged that by filing the second writ petition. After issuance of the notice in the second writ petition, he stopped this, he passed this
Yes,
order.
this
This order.
first petition was
First writ petition was,
against the rejection of
yes, ma'am.
rejection of your tender.
Yes, ma'am.
And second, and therefore order in that first writ petition order was passed,
Pass. Interim order was
not to
passed.
proceed.
Yes, interim order was
Then
passed.
they have
by the
issued the work order.
Work order.
Then you filed a second
The
writ petition
petitioner,
challenging the work order.
yes, my lord, the writ petitioner. filed
Then a notice was issued.
my lord.
There was any interim order on that
Uh,
second writ petition.
Second writ petition order is here, my lord.
Where it is?
At page 13, my lord. It starts from page 13.
That was stayed.
My lord.
Will remain suspended under further order of this court. Yes. Then this 90 order was passed.
My lord. Both the writ petitions were disposed of by the
7/3/20.
90 order was passed. Then my lord.
Yes.
Then, my lord, the final order was passed, which starts from page 22 by disposing both the writ petition, my lord.
Appeal is pending.
Appeal,
Please,
appeal filed by the other party part, not this contentment, not the government. No.
Ordered as final disposal. Against the final disposal of
Yes, ma'am.
writ petitions.
Yes, ma'am.
There only the order has been passed.
My lord,
The sumoto contempt has been registered.
yes, my lord.
Hmm?
Yes, my lord. Kindly come to page 40, my lord.
Hmm.
At page 40, my lord, para 36.
Hmm.
Though both the writ petitions are disposed of with the present order, the aspect of issue of violation of the order dated 2/11/2021 in read petition 5728 of 2021 by the then DFO Dhemaji, one Shri Rohini Kumar Das cannot be obliterated, more so when the violation is apparent. This court has further noted that in spite of a specific order passed by this court on 7/3/22 in WBC number 1608 of 2022, the second read petition, my lord,
Hmm.
directing the said incumbent to show cause as to why action under the Contempt of Courts Act should not be taken against him. Till now, no cause has been shown by the said incumbent, though an affidavit has been filed by the said incumbent on 16/3/2022. The affidavit was only to tender an apology and no cause has been shown at all in response to the order of the court. There is also no order passed by the court accepting such apology. This court has also noticed that the PCCF and HOFF has also directed to apprise the court as to why consequential orders should not be passed against the erring respondents of the Forest Department. However, till now, there is no response to the said directions contained in the said order, dated 7/3/2022. Accordingly, registry is directed to register a separate suo motu contempt proceeding against Sri Swenso, the then DFO Dhemaji, and issue notice to him. Such notice is to be sent. Basically, this is the fact, madam.
So,
There is an apparent error in his part, your lordship. I honestly accept that, your lordship, but this take on his part, that's why he's seeking an tender apology, your lordship, before this court, your lordship.
then you face the consequences.
We pray for an apology, your lordship, before this court. That from the records and seen that there's a mistake on his part. There has been a mistake, honestly accept that.
What about the tender now? It's of
This-
2021.
T20. Matter has been not yet listed once, thereafter.
No, no, I'm not talking about the appeal. What about the tender?
Tender-
It's stopped. Has it been stopped?
The tender has not been stopped, your lordship.
Tender.
Yes, that has not been stopped.
Who is working? You have directed to stop.
But we have stopped that.
Has it been stopped?
Thereafter, this.
Or it's
order,
already
the-
carried out?
Most probably the period has to be over, your lordship. But whether the period is over or not, that has to be taken into.
No,
account.
whether that has been there, that is.
After this order, that work has been stopped. But now that every mall has specific time period, your lordship, 5 years, 4 years, 7 years. So whether this mall time limit is over or not, that information I don't have.
But apparently there is a violation, I mean,
Apparently, that's
you have
why
violated the court's order.
we have violated the court's order, lordship, saying apology. Lordship. On oath, he says that in future, he'll be very careful on this, your lordship.
That is always. Yes,
My lord, I leave it to your lordship, my lord. It's a matter between the.
but you suggest, apparently there is a violation.
Yes, ma'am. It
But,
is happening. It is.
The
happening,
moment
madam.
he came to know the second order,
Ma'am,
he is directed to stop.
my lord.
Yes, that is.
And although the government has not filed an appeal, the appeal is, I don't know what, these directions are also
The whole
under
order is-
challenge or what?
They have, in the appeal, they have challenged the whole order.
No, if it is by a private
It
party,
is by a private party.
how can he challenge the direction for the observation that there is a
Because he was the-
violation of the
He
court
was the
order?
beneficiary in the writ petition, lordship.
Hmm?
The beneficiary of the writ petition, the letter of intent holder in that writ petition, the respondent has filed a challenge in this order.
So why have you not filed appeal?
My lord.
They have filed an appeal, your lordship, before we can.
No, no.
There is no
Cannot-
what they could have done.
Hmm. Yes, you suggest.
On oath, he has said in future he was never ever do this again, lordship.
No, apology,
And-
it's not, it appears to be mechanical. You are seeking apology, tendering apology. It's to be mechanical. There's no serious remorse.
He has remorse, your lordship. He has remorse, your lordship. Because he knows the consequences of a contempt, your lordship.
You face the consequences now.
This is the last chance, your lordship.
Apparently you have violated, knowing fully well. Order was passed on 2nd of November. You should do work order on after a month.
But he seeks an apology. There was mistake on his part. He likes that, your lordship. It's in his state and his oath, your lordship.
We'll see. Then this after 2 weeks we'll see. All right.
Mine.
G. Bush learned counsel for the petitioner. And also Mr.
R.R. Gogoi.
R. Gogoi.
R.R. Gogoi.
R.R. Gogoi. For the list contender. Who submits that. Who submits that. The Alice contender has not. No, the Alice contender inadvertently misread or misinterpreted the order dated 02/11/2021 passed in WPC. What is the WPC? 5728 of 2021. Therefore, there's no or in past in WPC 5728 of 2021. Mr. The list of and as soon as he came to know the order and properly interpreted the operation of the work order issued in violation of the order dated 02/11/2021 was immediately stopped and seized. List of. He submits that the Alice contender seriously tenders his unconditional apology with great remorse and assured never to engage in any disobedience of this court order, of the order of this court, and will refrain from and will not think of any defense of any order of the court in future. Mr. As prayed for by the learned counsel for Alice contender, let this matter be listed after 2 weeks so as to enable the alleged contemner to reflect on his action of non-compliance of the clear order of this court, directing not to proceed with the tender. You reflect on it. Or should we frame a charge,
Lordship, will reflect, sir.
giving another opportunity? Huh? You reflect over it,
Very well.
come up with some more better thing,
Explanation.
Nations alone.
better explanation,
Very well, Lord.
so that with the remorse, real serious
Yes,
remorseness, while tendering apology,
Very
not
well.
be
I'll-
mechanical.
Oble. This was here, my lord.
Yes,
Again, different court may not call them because this matter, other matter was going on. Again, he's on lex, my lord. So can it be taken after some time, my lord, or some other day, my lord?
Some other days.
Here only, my lord.
Since the list is around.
He was here only, my lord. Again, another matter, because the other matter took taken
it's
up,
very difficult.
my lord. It can be taken up any day in the next week, my lord, any day in the next week.
Tuesday.
Tuesday, my lord.
Yes,
April.
and this matter was heard in the first half at length, huh? At length as the same was heard in part. Due to absence of Mr. P. Nayak, learned additional advocate general appearing for respondents.
My lord,
Ama,
we'll
matter-
record on
matters
lex,
is-
my lord, on
matter
record,
is-
on lex, my lord.
Listed,
My lord will,
huh?
my lord will record on lex on in a different, not in absence, my lord.
He was not there.
Because he came here, my lord. Actually, he came here. He waited, my lord, also. But then what happened? The other matters were called before, my lord. 6 was the other matter, the other 2 matters which were fixed at 2. Because of that, my lord, because
Mr. However, in view of Mr. P. Nayak, learned additional advocate general for the respondents stated to be on legs in some other court, matter has been adjourned to be taken up in the second half. Mr. It is again informed by Mr.
A. Fukan, my lord.
A. Fukan, learned State Council, that Mr. Nayak, learned additional is still again on legs before some other court. Therefore, phrase for listing of the matter after the week. Christoph, considering that the matter is taken up
I think what do we-
as a last passed over matter, and there is no any other case for which the matter could be passed over again and again, comma. Let
Okay,
this
do
matter as prayed for by learned counsel for the parties, let this matter be listed after a week,
My lord, to 2nd of September.
after a week on 2nd of September.
Deeply obliged.